Yes.
Wait, please, your lordship. I beg to mention for listing a case, my lord, on 20th of this month, my lord. Obliged.
Meet please, your lordship.
Which date you want?
My lord. On
Let it-
admission.
Admission.
My lord. Matter was not listed for a long time, my lord. That is
Let it be on 11th.
on 11 dates. It will be difficult, my lord.
So some days later,
My lord.
11, 13, 15, whatever date you want.
Yeah, on 13, my lord.
On 13?
My lord.
Oh, it's on 13. Yes.
Obliged, my lord.
Meet please, your lordship. I beg to mention item number 27, my lord. In this matter, my lord, 27.
Yes.
In this matter, I am appearing for the FEDCL, my lord,
Yes.
and I am praying for listing of the matter after 2 weeks, my lord, to enable me to get instruction and file the affidavit, my lord.
Okay. Who's for the petitioner?
I have taken the consent, my lord, as what I could.
Okay. Mr. R.M. Dekalan, counsel appearing for the PDCL, submits that he'd like to file an affidavit on behalf of the respondent, prays for 2 weeks' time. He submits that consent of the counsel for petitioners have also been obtained, placed after 2 weeks.
And deeply obliged.
That please, your lordship. Item number today's 26. Today's list, my lord.
Yes.
Lokhiram Buragwa. My lord, this matter has become infactual.
The submission of Mr. N. Bora on instructions that writ petition has become infructuous, writ petition stands dismissed as infructuous. Interim orders, if any, stand vacated. Pending I's are also vacated, dismissed. Mr. So-and-so for elementary, so-and-so for finance. Yes.
Mark.
May I please, your lordship. Lordship, I beg to mention item number 10 of today's daily list, lordship.
10.
Due to some personal difficulties, can it be passed over for the day, lordship?
Have you informed the
Yes,
petitioner?
lordship. Yes, lordship.
Item 10, at the request of Mr. N. Kolita, matter stands adjourned for 1 week. It is submitted, consent of the writ petitioner has also been obtained. Yes.
Obliged.
Wait, please, your lordship. Lordship, I beg to mention for listing of a WPC, lordship. It was last listed on 10/1/2020.
Let it be on 13 March.
Lordship.
May I please, lordship? I beg to mention item 108 of high list. The matter may be adjourned for today and matter may be fixed on 29 February.
You give the number to the court master, will not call it up. Hearing list,
High list.
you give the number, not the number. Yes.
May it please your lordship, I will beg to mention item number 52. Kindly adjourn it for the day.
You are for the petitioner?
Yes, lordship.
Item 52 at the request of the learned counsel for the petitioner stands adjourned for 2 weeks.
May please, your lordship. Lordship, I beg to mention item number 4 of today's list, lordship. Lordship, 1 week time may be allowed to file my affidavit. There are some.
Yes, you are for the petitioner.
My lord.
Any objection?
My lord, after 1 week, it
Matter be listed after 2 weeks. She wants 1 week. So after that,
may be fixed.
no, you let her file the affidavit. You may like to file a reply. Why fix a date? Let the pleadings be completed. You are entitled to make a mention for listing it on a specific date. Item 4 at the request of MM Potaki, Learned Standing Council, Veterinary, Animal Husbandry and Veterinary Department, matter stands adjourned for 2 weeks. Mr. A. Manaf, Learned Counsel for the petitioner, does not object. List after 2 weeks. Writ petitioner, upon filing an affidavit in opposition, writ petitioner is at liberty to file a reply affidavit if so advised. List after 2 weeks.
Obliged.
Notice was issued in the matter.
So it should come up for admission.
Yes, my lord. Otherwise, also similarly placed persons have received the amount after an order from this honorable court, and I would like to place an order. But if your lordship allows me to place a list of similar cases, this matter can come up for admission along with this matter.
Very well. Matter be listed along with.
My lord, I'll give the list.
Yes.
Matters.
Give it to the court master.
My lord.
It is submitted. Similar matters are pending before this court. Therefore, prayer is made to have the matter listed along with the so-and-so writ petition. So, as per order dated 5/1/2022, it is seen that notice has already been issued. Therefore, matters be listed for admission. MS
S. Kumar.
S. Kumar appears for elementary education.
Lordship.
my lord, would be pleased to fix a date because overall matters.
When are those matters fixed?
My lord, these have not come up for a long time. My lord. This will come up with this.
You're appearing in all the writ petition.
Yes,
Matters be listed on
any date.
fourth.
My-
Fourth.
Obliged.
Yes.
matter participable non-payment of arrears salary matter. Last few occasions instructions was called for matter.
Any instructions?
Lordship, I received one instruction, Lordship. Arrears salary, it is under process, Lordship.
Under process.
Lordship,
Under process for receiving or not receiving?
receiving.
Receiving. How much time will be required?
It is not mentioned, Lordship.
We give you further 3 weeks time.
Lordship.
MSS, Board, Learned Council, Standing Council, Elementary Education, subjects. That's the proposal for grant of area salary to the petitioner with effect from 5/11/2020 to May 2023 is under process. And further time is necessary to update this court on the status of the proposal. So Mr. S. Hawk, Learned Counsel, appears for the petitioner. Taking into consideration the submissions made, matter be listed again after 3 weeks on April 3rd. Be listed on April 3rd.
Obliged.
Yes.
Lordship, this matter, a talukta will appear matter. This
matter, government appoint a talukda
will appear matter.
A talukdar.
A talukda. After some time.
After some time. Instructions are there.
Not in record, my lord.
Let it come on some other date.
Some of the details.
List on on 4th of March.
My lord.
Till then, the interim order may continue.
Interim order passed early will continue
Much.
until the next date fixed. Yes.
This is Lordship, instruction is short for Lordship. Petitioner is the
Irrigation. Who's for irrigation department?
Lordship. Petitioner is the retired employee of Master Worker Lordship. Their services are
Irrigation.
years.
Who's for irrigation?
Your service was deducted, Lordship. In calculating the actual amount of pension and gratuity, Lordship. That is the case, Lordship. Already, Honorable Court has already passed the judgment, Lordship.
No, that was the instruction sought for. Any government council? Yes. Who's for irrigation?
I will inform the irrigation department.
Please tell them we are keeping the matter day after. Day after
Lordship.
on Wednesday.
What is that?
On Wednesday,
Okay.
as the Learned Council, Standing Council for Irrigation is not present, matter will be listed on 26th. 28th. 28th. Mr. C. Bhattacharya appears for the petition. List on 28th
Obliged.
February.
Yes, Lordship.
Please inform him accordingly.
Lordship. Instruction.
Yes, what instructions? Tell us.
Family pension has been settled.
Settle.
Yes, notion may dispose of.
You show it to him. Give us that instructions. It is submitted by the respondents that the family pension payment order bearing number so and so has already been issued in favor of the writ petitioner. So a copy of the said instructions is placed before the court, which is kept on as the part of the case record. Mr. S. Hawk, learned counsel for the petitioner, submits that the FPPO having been issued in favor of the writ petitioner, no further cause remains in the writ petition. Accordingly, writ petition stands closed as the prayer of the writ petitioner has been granted by the department by issuance of FPPO bearing number so and so.
Right.
The writ petition is accordingly disposed of in terms of the above. Interim orders, if any, stand vacated.
Right.
Obliged, Lordship.
Yes.
Obliged.
There, please, Your Lordship. Must kindly peruse the last order of this honorable court. 24/1/2024.
Yes. Who's for secondary education?
Yes. Open the second.
Secondary education. See the last order
My lord, we have received the instructions. I have sent it through mail.
through mail.
Yes, Your Lordship. From Belando, Kaushik, Your Lord.
Well, we'll take it up after some time. Mail nikal. Yeah. Next. Matter to highlight.
On last occasion, instruction was sought from the
Lordship,
department
we have not received any instruction, Lordship.
regarding family pension.
Which department is it? Which department is it?
PHC, Lordship.
PSU. And
No instructions have been received. Why?
Lordship, extra copy not yet be served, Lordship.
Not served extra copies.
notice was not issued, madam. Notice may be issued.
But unless they receive extra copies, how instructions will be issued? Your notice was not issued because your only ground is for non-receipt of family pension. We wanted to find out why it was not.
I'll start. Case 51 is my regulation of that deceased husband is also pending, that instruction is not received. Page 51, my lord.
Pump operator,
Yeah.
okay. They heard learned counsel for parties issue notice returnable for weeks. MS, what is your name?
Argo good.
R. Gogoi appears on behalf of all the respondents.
1, 2, 3, and 4, Lordship.
1, 2, 3, 4, Mr. B. Chakraborty for respondent 5 and 6. Since standing counsels appear, notices are waived, extra copies be furnished within 1 week from today. List after the returnable date. Yes.
My lord, earlier weekend, my lord directed me to submit some communication. These are the communication. Is reflected in the office of the 21 November 2023.
Have the proceedings been initiated?
already initiated, my lord, earlier occasion, we have, placed him, under suspension, but, he was resumed his duty pursuant to an order of this court. It was different because, the take, controller of audited in the year 2023.
You bring it on record then. Let him file an affidavit on all the necessary
My lord,
documents.
earlier occasion, my lord, we have placed him under suspension on this, because, it is necessary to place under suspension.
Why?
Because every department has got a library, my lord. But earlier occasion, my lord, in those documents, he was placed under suspension.
You bring it on record. Why are you not bringing it on record? Mr. Dotto, please bring it on record. File an affidavit, bring whatever documents you want, bring it on record.
My lord, here also, my lord, have a look on the order dated. Order dated 21/12, 2022.
Page
I
number
did. Page 40,
40.
second paragraph, my lord. Petitioner Dr. Rubajiti Petia is an additional professor in the Department of Psychiatry Department in the Lokopriya Gopinath Board Regional Institute of Mental Health at Tezpur. The petitioner was issued a show cause notice dated 23/9/22 by the OSD in charge of Deputy Director of LGB RIS wherein it is in the first paragraph, it is stated that with reference to file number such and such, the petitioner who was also in charge of the library had failed to submit the list of books recommended by the faculty members, and the delay in doing so was not justified in a satisfactory manner. The OSD in charge deputy director in second paragraph provides that the authority have sufficient reason to believe that the petitioner has been deliberately and repeatedly refraining from complying with the official instruction of the competent authority. Third paragraph provides that the conduct of the petitioner is not providing the list of books recommended by the faculty members has caused serious inconvenience in public service and wastage of precious time of the government. The fourth paragraph provides that the act of not providing.
What are you trying to submit on? What are you trying to project?
My lord, that
Do you want to file a counter affidavit or you?
Yes, my lord.
So please file it. We'll hear the matter.
My lord, because it is amply clear that he has taken some documents unauthorizedly.
No. If you want to proceed for hearing, we can hear it. But if you want to file something on record,
yes, my lord, I have to.
Then that is what we are asking you for the past 10 minutes. Heard learned counsel for the parties, Mr. E.K. Dr. Learned CGC or standing counsel.
Standing and CGC also, my lord.
CGC and standing counsel
Of
LGBRIMH submits that you'd like to file a counter affidavit assailing the contentions made in the writ petition. Prayer is allowed. Matter be listed. After how much time do you require?
My lord, we need to, my lord.
May be listed after 4 weeks. Mr. K.K. Fukun, learned counsel, appears for the writ petition. Matter be listed again on the 5th of April till the next returnable date, interim order passed on 29/1/24 will continue. It is made clear that this interim order will not preclude the departmental authorities from proceeding and concluding with the departmental proceedings initiated against the writ petition. List accordingly on 4th of April. What did we say? 4th, 5th of April. You can take back the papers. Yes. Aledu. What is this instruction? What instructions is this?
So the NOC has not been received from
That
the
we know,
school.
therefore we wanted the respondents to find out why the NOC was not issued by the principal. And the joint director writes a letter to inspector saying that this is in your jurisdiction, please write. Is the director powerless to call for the information when the court directs? We are not concerned with your intra-departmental communication. Do you represent the director and the inspector?
Yes, Your Lordship.
Then why are you putting this instruction before us?
This is the only instruction that we have.
This is hardly an instruction to be placed before the court. If you have no instructions, you say no instructions. You tell your clients that these are instructions not to be placed before the court.
So the next.
Joint director says, this is within your jurisdiction, please get it. Is that what you are trying to submit before the court? That the director is powerless to get the information?
Your Lordship, from the
Sorry?
school. The NOC has not been received, Your Lordship.
We know that is the basis of the grievances. That is the grievance of the writ petitioner. And the director tells us that it is the jurisdiction of the inspector.
Lordship, kindly 1 week more time, Your Lordship.
We will issue directions to your director to apprise the court why the NOC has not been issued. These kind of instructions are not to be placed before the court. In fact, I'm surprised that you are even accepting this as an instruction, as a counsel. What kind of instruction is this? Have you received any instructions from the inspector?
No, Your Lordship.
Then, by the last order, take down, by the last order dated 24/1/2024, the Standing Council Secondary Education was permitted to obtain instructions as to why the NOC by the principal in charge of Bikram Chand Balika Vidyalaya Higher Secondary School, Karimganj, has not been issued in respect of the writ petitioner. Or in enabling him to obtain get the pension?
Gratuity, Lordship.
Huh?
Gratuity, Lord.
Gratuity
And some areas.
and some area of the salary. Stop. Today, when the matter is called up, MS H. Terangpilla Standing Council, Secondary Education has placed before the court a communication from the joint director to the inspector requesting for the information. Stop. However, The instructions as to why the NOC has not been issued by the principal of the school is not before the court. We permit the respondents to complete their instructions in this regard, and we issue a specific direction to the respondent number 2, the Director of Secondary Education, to apprise the court as to why the NOC has not been issued by the principal in charge Bikamchan so-and-so school by the next date fixed. Two weeks further time is granted to the respondents to complete their instructions. Matter be listed again on 11th,
Black.
11 March.
Master Black.
Mr. M. Khan appears for the petitioner.
May it please your lordship. Lordship, hearing this matter, lordship, I need 1 week further time to obtain my instruction, lordship. Lordship.
What was the issue here? Suspension.
Suspension.
Whether review has been taken, carried out or not.
Lordship, that instruction, lordship, I'll place, lordship. Let it come after a week, lordship, I'll place that.
Yes, Mr. Ali.
Milord.
Mr. D. Upamanu, learned counsel to the petitioner, prays for and is granted further 1 week's time to obtain the instruction in the matter. Learned counsel for the petitioner does not object. Matter be listed again on 11 March.
Highly obliged.
Obliged. Yes.
Here the respondent is directed to bring some instruction, lordship. Matter was lordship related to non-grant of superannuation pension in spite of the honorable court's order, lordship. The honorable court's order is at page 37.
Writ appeal order.
Writ appeal order. Page 37 is the relevant. Thereafter, lordship, they have passed the order in compliance of the honorable court's order. They have passed the order at page 41. That he is entitled for superannuation pension in terms of honorable court's order. But now, lordship, they have stopped my retiring pension also, and the superannuation pension has not been granted till date. They're asking me to, lordship, refund the retiring pension amount and gratuity, etc. Thereafter, they are saying that they will pay me the superannuation pension. Therefore, honorable court has last time directed the respondents to bring the instruction, lordship, as to why the retiring pension has been stopped, lordship. Pension cannot be stopped, lordship. Now, without pension, the petitioners are, lordship, leaving, lordship.
My lord, I pray for some time, Lord, some developments are going on. The authorities are in fact considering their request, my lord. I pray for some time. The calculations have to be made, my lord. Some amount has to be recovered.
You recover it, but why are you stopping the pension?
My lord.
Whatever amount you, according to you, needs to be recovered, you recovered.
At page 61, they have admitted that they will adjust it, but at page 61, the DGR, Director General of Assam Rifles, has returned to the unit and Assam Rifles. But nothing has been.
We keep 7 days time, my lord.
At the request of Mr. Gupta, learned standing counsel, matter stands adjourned for 2 weeks. Mr. A. Tobildar appears for the petitioner. After 2 weeks.
My lord. All the 3 items.
Not it.
All
It
3
paid
items.
this because of the pension matter.
11 March.
11. Not
Obliged.
obliged. Not.
Yes.
May it please your lordship. Well, my case is under Assam Employees Pronam Act, my lord.
Employees?
Assam Employees Pronam Act 2017. Well, Long name is Assam Employees Parents Responsibility and Norms for Accountability and Monitoring Act 2017. But as per this act, my lord, the authority can deduct up to the 15%, my lord, from the salary of an employed son for maintenance of the parents. That is the main, my lord. It is 10%, my lord, and if a special case, it may be deducted up to 15%. So, my lord,
But there has to be a finding
my lord,
whether you are being maintained, not maintained. This is your
my lord,
allegation
my
that
lord,
he.
that is why, my lord, my son, I am widow, my lord, my son, my wife, my husband was working as an employee of the municipal corporation, municipal board, Mongoldoy, my lord. And thereafter, my lord, he got the employment there in place of his father, but he is not maintaining me.
So that is what
And
we are
that
asking.
I have filed representation before the municipal board, my lord.
Yes.
So, my lord, municipal board
Yeah.
is duty bound under this act to deduct 10% from his salary for my maintenance. That is not done. That is
Where are the rules? When has this? When has this? How is this act being implemented? Where are the rules?
my lord, rules is there, my lord. Rules is fine. My lord, I'm sorry, my lord, rule is not available with me, my lord.
It has to be.
But thing is, my lord,
No, but how it will be implemented unless the rules are there?
my lord, here extends, it extends to whole of Assam. It shall come into force on such date as the state government may by notification in the official gazette appointment. It is an act of
No,
2017.
act is okay, but there has to be a set of rules.
My lord, in that case, my lord, my humble submission before your lordship, my information is this, my lord, it is in operation. But regarding rule, my lord, that is not available with me now. But we are getting the information even in the electronic media.
So why don't you file it before the designated authority?
My lord.
Who is the designated authority?
My lord, designated authority, your lordship, that is the appointing authority, my lord, that employee. Designated authority means the officer. Your lordship would be pleased to see F.
Where is your representation?
Yes, my lord. My representation, I am placing, my lord. Means an officer or functionary of the state government or the organization, as the case may be, or such officer or functionary not below the level of drawing and disbursing authority. So I filed my representation to chairman, my lord. That is
Where is that
yes,
representation?
my lord. I am placed. Representation to court, your lordship would be turn to page 26, my lord.
26.
It, no?
Yes.
To chairman, my lord, Mongoldoy Municipality Board. Robiul Hussain is my son, my lord. He is employee of the municipal board. It was filed on, my lord, 13/12/2023.
This has not been disposed of.
Not disposed of.
There is an appellate forum here. Have you approached the appellate forum?
No, my lord, question is this, my lord. My humble submission before your lordship. Question of appellate forum, subject to correction, my lord. Question of appellate forum will come if that is done, my lord. If it is
Kindly look into.
no order has been passed.
Kindly look into section 11
Yes,
of the act you have placed before the
my
court.
lord. Section 11. Right to appeal.
Yes.
If the designated authority does not dispose of the case within the stipulated period of 90 days, the dependent parents or debang siblings or employee has the right to appeal before the appellate authority as per the procedure as may be prescribed. So, Lord, my humble submission before your lordship that if it is not disposed of,
This is your case, it is not disposed of.
that is there.
This is your case,
Yeah, it is not disposed.
disposed of.
Yes.
So you have a right of appeal if it is not disposed of.
My lord.
So you file an appeal before the appellate authority.
So, my lord, may I pray before your lordship that with that observation may the petition.
No, we will not observe.
My lord.
Why should we observe? You are relying, see, in your writ petition, there is not a single averment that you are claiming your rights under this act.
Act is not mentioned. My lord.
Not mentioned.
To that, my lord, my
So
humble
your-
submission before your lordship.
Wait.
I
Your
may not make a
prayer,
statement regarding law.
kindly come to your prayers
Yes.
at page
Yes,
7 or 8.
yes, my lord.
Your prayers are very specific.
My lord.
Your prayers are with regard to recovery of the shop
My lord.
from your son.
Let me see, my lord.
Page 8.
My lord, B.
Start from A.
A is direct and command to recover the shop. B, direct command to respondent to issue a direction to the respondent number 5 to pay an adequate amount of money
Under
out of
what?
his monthly salary to
Under
the
what
petitioner
provision?
for maintaining herself.
Under what provision of law?
My lord. That regarding provision, my lord, my humble submission before your lordship. Law may not be stated before your lordship, but if it is placed, my lord, that will be looked into by your lord.
No, but the purpose of a pleading is to enable the opposite party to understand what allegations have been made so that they may rebut it by filing another set of pleadings called the affidavit. Now, unless you are very categorical in your pleadings, what you want, what right has been violated, how will they respond? You have not mentioned the law. You are within your rights to place the law. We accept that. But the law you have placed also has an alternative remedy, which is the remedy you are seeking for.
That is there, my lord.
So you may file it. And it is within 90 days. After 90 days. So
Yes, my
your
lord. 90
application.
days, 90 days is over, my lord.
So now you can file it. You file it. You withdraw the writ petition and file it.
Yes, my lord. I will.
Heard learned counsel for the writ petition. The learned counsel refers to the Assam Employees Parents Responsibilities and Norms for Accountability and Monitoring Act 2017. In short, called the Assam Employees Pronam Act. The learned counsel for the petitioner submits that under this act, the petitioner's rights of being maintained by her son, namely respondent number respondent number 6.
6, yes.
She has a right to be maintained by the respondent number 6, as she's how old is she? What is her age?
77 years.
She's a senior citizen. And
70 years, my lord.
and therefore, under the provisions of the Act, she is entitled to be maintained by the respondent number 6, as he is working under the Mongoldoy Municipality Board by being offered appointment on compassionate ground. He was appointed on compassionate ground
Yes, my lord.
in place of her late husband, namely so-and-so, who expired. Stop. Mr. Sheikh has pointed out the various provisions of the Act. Para. Having heard learned counsel for the parties, and upon a careful perusal of the provisions of the Act, it is seen that under Section 11, there's a right to appeal. Section 11 reads as under para so and so. Learned para. The limited prayer urged before this court is that in spite of the representation dated 23/12/2022 filed before the municipality authorities seeking maintenance by deducting an amount from the salary of the of respondent 6, they say representation has remained pending without any effective orders being passed. Stop. If that be so, the Act of 2017 provides for a remedy under the statute, being Section 11, which provides for filing an appeal before the appellate authority prescribed under the Act. Stop. At this stage, Mr. Sheikh fairly submits that you'd like to withdraw the writ petition at this stage and approach the appropriate authority, filing the appeal as prescribed under Section 11. In view of such submissions, writ petition stands dismissed as withdrawn. MS A. Talukdar appears for the respondent authorities.
So 1, 2, and 3, Lord. 1, 2, and 3.
1, 2, and 3. Stop. If any appeal is preferred by the petitioner under Section 11 of the Act, the same shall be disposed of in terms of the provisions of law by the appellate authority.
And the only thing is that representation dated 13/12, not 23, 13/12/2023.
Page number?
Page 26, madam.
13/12. 13/12.
Obligation.
Bless Lord.
This matter relates to non-payment of arrears salary, my lord. My lord, the petitioner was appointed as a grade 4 employee on 30/9/2012, my lord. Thereafter, my lord, for the next 5 years, my lord, she did not get any salary, for which she preferred a writ petition, my lord. If your lordship will kindly see page number 22 of the petition, my lord. Page number 22. Last paragraph, my lord.
Yes.
Accordingly, a writ of mandamus is issued to the respondents to pay the current salary of the petitioner from the month of May 2017. The arrear payment of salary to the petitioner from 39/12 shall be made by 31st July 2017. If the payment aforesaid is not made in terms of the directions above, the petitioner will be entitled to interest at the rate of 6% from 39/2012. Be paid by the current incumbents who are arrayed as respondent number 1 to 5 in this petition. But thereafter, my lord, the current salary was paid, but the arrear salary for this period has not been paid as on date, my lord. So that is the grievance.
Area salary for which period?
From my lord, 39/2012 to my lord, 31st
This
July.
order is already there.
Yes.
Then
After that, my lord.
why have you filed a second writ?
Well, on 3 occasions, my lord, they sent proposal to the director, my lord, from the block elementary education officer. But at the director level, my lord, nothing has been done.
Your appropriate forum would be a contempt.
My lord, we did not prefer a contempt, my lord, because in this order, my lord, no specifics were mentioned, my lord, with regard to the calculation or something on. It cannot be said that, my lord, the
All
respondent.
right, heard learned counsel for the parties. This writ petition is preferred with a limited prayer for release of the payment of area salary to the writ petitioner. Stop. The facts involved in this case have been described in the order dated 17/4/2017, passed in WPC 5850/2017, whereby the writ petition preferred by the petitioner earlier stood disposed of with a specific direction to the respondents to pay the current salary as well as the area salary. The directions in the passed in the writ petition are extracted as under. Accordingly, page number 22. Para. It is submitted that although the current salary has been paid,
Yes.
current salary has been paid, but the area salary has not been released and no information was forthcoming from the respondents as to why the area salary has not been received. Para. MS Quor, Learned Standing Council, appears for the Education Department. Any appeal filed
Lordship,
against this order? Any appeal has been filed?
no, Lordship.
Are you sure?
I think no, Lordship.
If it is submitted that no appeal or review has been filed against the order dated 17/4/2017, passed in WPC number 585 of 2017. Whereas this court, upon hearing the learned submissions of the learned counsels for the parties and upon careful perusal of the writ petition, as well as the order dated 17/4/2017, passed in WPC so and so by a coordinate bench, this court is of the view that there is a writ of mandamus that issued to the respondents to pay the current salary as well as the area salary for the period. And if the payment is not made, then the petitioner was held to be entitled to an interest of 6% from 13/9/2012 to be paid. Stop. In spite of such clear and specific directions, although the current salary was released, the area salary has not been paid. Stop. Under such circumstances, this court finds that where a writ of mandamus has already been issued, no further writ is called for in this matter. However, considering the fact that the current salary has already been released, we permit further 60 days time
Okay.
to release the area salary as directed in terms of the order dated so and so, passed in WPC so and so by the coordinate bench. It is made clear that since the area salary of the petitioner has not been released by 31st July 2017, the petitioner will be entitled to an interest of 6% from 13/9/2012 to be paid in respect of the area salary. Stop. The authorities will comply with this order within a period of 60 days from the date of receipt of a certified copy of this order to be placed before the respondent authorities. Writ petition accordingly stands disposed of in terms of the above. Mr. P. Nayok appears for the respondent number 6. A score for all respondents, 1 to 5. 1 to 5. Writ petition accordingly stands disposed of. Notwithstanding the order passed, the respondents are at liberty to verify the claim of the area salary made by the writ petition. Disposed.
Highly obliged.
May I proceed?
Yes.
My matter is very pretty, so Lordship. Only because of that, Lordship, non-issuance of last payment certificate, Lordship, my pensionary benefit has been held up, Lordship, since a long year, Lordship. My father was working as a late CGD Ananta Kumar Sharma, 12 Battalion, Sasota Simapol SSB, Kishanganj, Bihar, Lordship. Then thereafter, Lordship, my father died in a road accident, Lordship, while he was on duty, Lordship. And subsequently, Lordship, pension has been granted to my mother, Lordship. And after receiving 1 year's pension lordship, but she eloped with someone else lordship. At that relevant point of time lordship, I was minor, having aged about 7 years lordship. Then thereafter lordship, the several communication has been made out with the authority lordship, but authority has not released the pensioner benefit, only showing down that the last payment certificate has yet to be furnished lordship before the authority lordship. I am unable to furnish the same lordship as because at the relevant point of time lordship I was minor lord. Then the use authority has not assessed and furnished the last payment certificate lordship. Then how it is possible for a girl lordship while he was minor lordship? How can she furnish the same lordship? Even lordship, the Honorable High Court specific direction lordship on 9/8/2023 lordship annexer D page number 24 lordship directed the respondent authority lordship to furnish the pensionary benefit lord. And thereafter lordship communication has been made out lordship in between the authority lordship one to another lordship. That is the communication your lordship. Page number 27 annexer E lordship, kindly be paid lordship. Page number 27. This communication has been made the pay and accounts officer, legal cell, Chanton Pension Accounts, Accounting Office, Bikaji Kampa, New Delhi lordship. And stated that lordship, kindly refer to your email dated so regarding return of original disbursed portion for authorization of family pension to unmarried daughter Krishna Sharma. In this regard, please find enclosed here with the original disbursed portion for your necessary action. We also state that we have received the original disbursed portion of PPO from the pension paying branch on so. However, the said branch did not provide last payment certificates due to the reason given as no last payment record as it is too old. So, lordship, the one authority has stated another authority, lordship, that because of that, lordship, the last payment certificate has unable to provide as because it was too old, lordship. Then, lordship, what to do, lordship? How can I furnish, lordship? So this is the duty bound of the authority, lordship, to assess the same lordship by intimating to one and another lordship. Otherwise, lordship, I'm not able to receive the pensionary benefit. In this regard, lordship, I have filed another representation, lordship, annexer E, page number 28, lordship. In my representation, I clearly mentioned, your lordship, the relevant page number 30, lordship.
You have to array the bank authorities as respondents.
Yes, lordship, I have already added bank authority, lordship, as
You have
respondent number 6.
Respondent 6, okay. Anyone for respondents here?
But lordship,
CGC?
according to my knowledge, lordship, the account officer is the competent authority, lordship, to assess the same.
We'll find out.
Yes.
You serve copies on the SBI authorities.
Yes, sir. My duty bound now. I have already
Hard
filed it
Learned
with them.
counsel for the parties. Let the respondents represented by Mr.
KK Mehdi appearing for respondent number 1, 2, 3, 4, and
Mr.
5.
Mehdi appearing for respondents
1, 2, 3, 4, and 5 on behalf
1,
of
2,
Mr.
3,
S.
4, and 5. Obtain instructions with regard to the grievances of the petitioner. Stop. Since no counsel appears for the SBI, the petitioner will serve extra copies. 2. The petitioner will take steps on respondent number 6 and 9
9.
by Dusty. As well as by registered post. Dusty routed through the registry of the office, registry of the High Court, as well as by registered post. Let the matter be listed again after 3 weeks, enabling the respondents to obtain the required instructions in the matter.
Kindly
Extra,
obtain.
extra copies be furnished to Mr. Medier within a period of 1 week from today.
Oblige. May I please, Lordship? Lordship, in this case, petitioner was serving as the assistant teacher at Naharni High School at Golaghat, my lord. And the respondent number 8 was working as Santipur Milan High School at Baksa, my lord. What happened, my lord? The respondent number 6, the headmaster of the Golaghat, Naharni High School, Golaghat, my lord, he took the petitioner's ID and user ID and applied for a mutual transfer, my lord.
You have to array the headmistress also by name.
Yes, I have added, my lord. It's respondent number 7, my lord.
She is the assistant teacher.
He is the in charge of that school, my lord.
And and to whom was it supplied?
It was supplied to third, my lord, for respondent number 7, my lord.
By whom? By whom?
Respondent number 8 is my lord, headmaster, my lord. Sorry.
No, you say it is the in charge headmistress.
No, headmistress, my lord. Page 6, my lord.
Huh?
Page 6. I have added her as respondent, my lord.
Kindly come to paragraph 5.
Yes, my lord, in charge.
In charge
In charge
headmistress.
headmaster.
Then in charge headmistress is not arrayed by name. You are making an allegation that she has misused your password. You have arrayed her
No.
only as a headmistress in charge. She has to be arrayed by name. You are making a specific allegation.
Yes, my lord. And my lord, moreover, my lord.
No, you first array her because we'll have to issue notice.
My lord, it is 7, my lord. She is the in charge. That is why assistant teacher, my lord. 7.
Do you read your pleadings before you make submissions? You don't. Kindly come to para 5, what you have stated here. Matter adjourned for 3 weeks, enabling the petitioner to array.
After some time, my senior will argue with me. After some time, my lord.
No, after some time. You array the party.
My senior will argue, my lord.
So why did you open up if you are not prepared?
Sorry, my lord.
Who is your senior?
Yes, Islam, my lord.
Call him.
May please, your lordship. Petitioner before your lordship, he is a physiotherapist, my lord. He was posting at Koringal, my lord. He is the only son, my lord, his parent, my lord. Accordingly, for transferring, he filed a representation, my lord, at page 23, my lord. Before the mission director, my lord. Mission director, National Health Mission, Assam, praying for transfer from Koringal to Dima, Assam.
Yes.
Accordingly, my lord, Dimasa also given NOC, my lord, they have no objection, my lord, page 26, my lord.
Yes.
The lordship only to my humble submission, my limited prayer, my lord, and the representation may be disposed by the authority, my lord, this is pending, my lord.
Where is the representation?
Page 23, my lord.
23. Mission director. What is the prayer, specific prayer here?
This is the, yeah, my lord.
You want to go back to Haflong?
My lord.
Yes, what do you say?
Actually, as per transfer policy of NHM, my lord, the application should be submitted on online mode, my lord, for or transfer on request or mutual consumption.
But it is there already. Do you deny receipt of this? Then There are, the NC Hills has already granted
My lord.
approval.
As per transfer policy, my lord. The prescribed
But
format
have you informed the petitioner at least that as per transfer policy, it must come through online? No. Does it say it will be rejected?
No, I have not said that. Ma'am.
No. Does your policy say if it is not online, it will be rejected?
Yes, ma'am.
Let us see.
Prescribed format at দিব লাগে online mode.
When were you transferred in Karimganj?
Also, can you see at page 21, my lord. He was transferred on 1/6/2023, my lord. Accordingly, he joined, my lord, and continues his working. Thereafter, he filed a representation, my lord.
The policy requires online application.
Then petitioner may be allowed to file a fresh representation, my lord. There may be considered, my lord.
All right. Heard learned counsel to the parties, this writ petition is filed by the petitioner, praying for a transfer, seeking a direction to the respondents. Authorities to consider the request for transfer and posting of the petitioner in his capacity as a physiotherapist from Karimganj Civil Hospital to Haflong Civil Hospital. Stop. The learned counsel for the petitioner, referring to the representation filed by the petitioner, submits that he is sought for the transfer back to Haflong on the ground that he has old aged parents who are in constant need of medical care and attention, and he being the only son, in his absence, there is none to look after them. Stop. The learned counsel for the petitioner has also referred to communications issued by executive member in charge health, family welfare and NHM, North Kachar Hills Autonomous Council, Haflong, who has recommended the transfer of the petitioner back to Haflong. Stop. Similar communication has been issued by the Principal Secretary NC Hills Autonomous Council. Stop. In spite of such communications, the authorities have not passed any order in the representation dated 29/9/2023, stated to have been filed by the writ petitioner before the mission director NHM. Stop. There are MS learned counsel for the NHM has placed before the court the transfer policy of the NHM issued by communication dated 21/8/2012. Stop. In respect of transfers on request, all applications, you write as per the said transfer policy. In respect of transfers on request, all applications are to be submitted in prescribed format. It doesn't talk about online. It says there is a format you have to download and send it there. Why are you saying it is online application? There is no online requirement. You see, and tell us if there is an online requirement.
Prescribed format.
You said online. There's a difference between online and prescribed format.
Prescribed format which can be downloaded from the online.
In respect of transfer on request as per the so and so, the requests are to be made on a prescribed format which is available in the portal of the NHM and which is required to be downloaded. Stop. As per the said policy, requests made in any other format will not be considered. Para. Learned counsel appearing for the NHM submits that the representation of the petitioner is not in the prescribed format, and perhaps that is the reason why the representation has not yet been considered. Stop. Para Mr. Learned counsel for the petitioner submits at this stage that if that be so, then he be permitted to resubmit his application in the prescribed format. Such submission is not objected to by the Learned Standing Counsel NHM. So, para. In view of such submissions made, the writ petition stands disposed of without expressing anything on merit, permitting the writ petitioner to resubmit his application in the prescribed format as per the transfer policy maintained by NHM by their communication dated so and so. Stop. Once such an application is submitted in the prescribed format, the respondent authority, namely the mission director, respondent number so and so, will consider the application and consider the application sympathetically and pass necessary orders. Writ petition stands disposed of in terms of the above. The representation, if so submitted in the prescribed format, will be disposed of within a period of 30 days from the date of receipt of such copy of the representation along with a certified copy of this. Writ petition stands disposed of. MSR Deca appears for NC Hills. Disposed.
May I please, your lordship? Lordship, this is the case for non-payment of the area of salary, my lord. What happened, my lord, the petitioner has joined in his service in the gist, my lord, Juran Institute of Science and Technology, my lord. On the date of his joining, my lord, he has been done wrong payment, my lord. His salary has been paid till date, my lord, in the wrong assessment of the payment, my lord. And accordingly, my lord, the principal, the respondent number 4 has submitted a details report before the authority concerned. That is available at page 23, Annex 7, my lord. My lord, this calculation is up to 22 July, my lord. And till July, my lord, my area salary was 6,53,127. It may be increased, my lord, till date, my lord. Till date, my lord, it has not been resolved, my lord. This is my case, my lord.
Yes.
Lordship, I have to obtain instruction, Lordship.
Get your instructions. Heard, Learned counsel for the parties. The grievance of the petitioner is for a direction to the respondents to release the area salary with effect from December 2010
10
till date. Stop. Such direction is sought for in view of the fact that in spite of representations dated 24/8/2023 filed before the Director of Technical Education, the prayer made by the petitioner has not been addressed. Stop. At this stage, the court does not feel it is necessary to issue notice. However, the extra copies be served on the standing counsel MS so-and-so appearing
B. Sinha appearing on behalf of D. Upamanya.
appearing for all respondents.
For respondent number 1 and 2.
1 and 2.
No, all my lord.
Who is appearing for 3 and 4?
All my lord. They can appear all my lord. This is the government college, my lord.
You are appearing on whose behalf?
D. Upamanya.
D.
Upamanya.
Upamanya. He is a higher education. He can get it on behalf of all. On behalf of all the respondents. Let the instructions be placed before the court within 2 weeks. Extra copies be furnished to the standing counsel to enable her to obtain instructions. Matter be listed on 13th March.
Obliged, lord.
Obliged.
This matter relates to non-payment of arrears salary from March 2015 and current salary lordship. The case of the petitioner is that she was appointed as stipendiary teacher in the year 1996 lordship, and thereafter, as per condition of the appointment, she was she was sent to the training lordship, and after completion of the basic training, she was allowed to do the regular school of pay, and she was getting from from March 2012, she was getting her salary lordship. Then in Shivsagar district, due to some allegations, she was appointed beyond the access court. Then her salary was stopped. Then lordship, the petitioner filed a petition to the concerned officer's lordship, and pursuant to that, the deputy secretary conducted an inquiry lordship. Kindly see the inquiry report at page 30 lordship, dated 9th May 2012, page 30. Page 30 lordship. May I read lordship? With reference to the above, I am directed to say that from your report, it reveals the name of 8 petitioners. Lordship, similarly situated 8 persons at their lordship are within the 610 LP post allotted for Shivsagar district against 8153 post created by so and so dated 18/1/95, and the incumbents were appointed by the Deputy Inspector of Nazira initially. It appears that out of so and so LP post were retained temporarily up to so and so, including the 610 LP post under Deputy Inspector of Schools Nazira Bhai letter number so dated so and so. From record, it also reveals that the name of 8 petitioners along with relevant information was submitted by the then DI of Schools Nazira Bhai so and so lordship. And subsequently, 275 number post of LP teachers, including 388 posts under DI of Schools Nazira Bhai, converted to non-planned by letter so and so dated so and so. The name of following 5 petitioners were also included within the incumbency list of so and so teachers we have Nazira lordship. Now lordship, in second box lordship, serial number 2, my name appeared Bhanu Gogoi. In last box lordship, Bhanu Gogoi, my name appeared lordship. Now lordship, kindly see page.
No, your name has not been traced.
No, lordship. The 5 were defined lordship. However, the names of 8 following LP teachers could not be traced out of the above incumbency list, although their names particulars were submitted by DI schools by letter number so and so lordship. Subsequently, my name was sent lordship. Now lordship, kindly next page 31. Next page. In view of the above, you are requested to examine the matter properly based on authenticated records and submit a detailed factual report as to why the name of 8 aforesaid incumbents were included within 1528 access LP teachers under DI of Schools Nazira in Shivsagar district, whereas as per record report, all those were originally appointed against sanction post height so and so, dated so and so, up to temporary after detention 22 lordship. This is the lordship findings. Those I am appointed against the sanction post. Now lordship, pursuant to this report lordship, then Deputy Director wrote a letter to DO lordship on 17th May 2012, page 32. Thereafter, nothing has been happened lordship, page 32.
Then I approached this honorable court, Lordship, along with 5 other persons. There's page 33, Lordship. Page 33, and 5 petitioners are there. And page 35, I am Bhanu Gogoi, my serial number 6, Lordship. And now, Lordship, I want to take, Lordship, the relevant direction of this court, Lordship. Page 39. Page 39. By order dated, Lordship, it is passed on 6/5/2014, Lordship, page 39, 11%. Lordship, may read, Lordship.
Yes.
Accordingly, a writ of mandamus is issued to the respondent authorities to pay the current salary of the petitioner within a period of 1 month from the date of receipt of this order, and to release arrears salary of the petitioners within a period of 3 months from the date of receipt of this order. The above respondents are also given a liberty to complete the inquiry stated to have been undertaken pursuant letter. Thus, I have shown, Lordship, this letter, Lordship, of the petition. It is, however, made clear that petitioners will continue to receive their salary unless a contrary decision is taken pursuant to the inquiry conducted, in which petitioner will to liberty and to take recourse of the satisfaction, Lordship. Lordship, my salary thereafter pursuant to this order, they have released my salary, page 40, Lordship. Page 40. Supernumerary post created, and my name appeared, page 40, serial number 20, Lordship. Bhanu Gogoi, Lordship. Last one.
Yes.
This is 31/3/2012 to 28/2015. My salary, arrear salary has been given. Now, Lordship, thereafter, page 41, Lordship, pursuant to the order of this honorable court, the Bullock Limited Education Officer Nazira called me with a relevant record, Lordship, to appear before the circuit house, the concerned officer. Page 41, Lordship. This is a type copy, Lordship.
Yes.
I appeared with all record, Lordship, and submitted my everything, Lordship. Page 41. That is dated 18/9/2014, Lordship.
Yes.
Now, Lordship, after that, Lordship, my salary has not been paid. Again, I approach this honorable court, Lordship.
Yes.
That is page, Lordship, 43, Lordship. Page 43, and 11%, Lordship, will find page 47, Lordship. Last, it is stated that as per earlier order dated 6/5/14, the petitioner were paid salary and allowances up to February 2015. And therefore, their salary and allowances from March 2015 till date would be constituted to be arrear salary. The current salary henceforth shall be continued to be paid till a decision is arrived at, and the respondent shall pay the arrear salary from February 2015 till date. The writ petition disposed of, Lordship. Now, this is the last order. Nothing has been done, and I am still continuing, Lordship, page 49. Nothing has been done, Lordship. She is very poor person for last, Lordship.
No. What was the direction?
There's a 2 order, Lordship. Pursuant to the earlier order, I have been paid salary from February 2002 to March 2015, Lordship. From March 2015, I was not paid salary. Then again, I approached this honorable court by filing WBC number 3628.
So what is the finding at page 47?
47, Lordship. 47, Lordship, from 47, second paragraph, Lordship, it is clearly mentioned. From a consideration of the extent, second paragraph, taken by a respondent, Education Department in the affidavit of the Commissioner and Secretary, it appears that contrary decision as contemplated in the earlier order 6/14 and not yet been arrived at by the respondent authority. In charge of the matter, this court cannot take another contrary view and is bound to follow earlier order action of this honorable court dated 6/5/14. Just I have shown, Lordship. Accordingly, this.
Now, why have you filed a writ petition again?
Now, Lordship, nothing has been done, Lordship. After that, there is a continuous direction, 2 direction.
You filed a contempt.
Lordship, the
Why
time
have
is
you
over,
not filed a
Lordship.
contempt?
There is order on, Lordship, 1 year already, that's discussion 16, Lordship.
What can we do?
17.
What can we do? Why should we issue another writ allowing you to file a contempt?
That is your, Lordship. It is to the order of
Your order is there.
28/4/17.
Your order is there.
Let them take a decision on what decision they have taken. There's a 2 directions.
They have not taken, then there is a forum for you to approach. You did not approach. What reasons have you given for not approaching the court?
That is,
What reasons?
Lordship, they are not getting salary, very poor person, and not how
That
they
is
are.
all right, but you have an order in your favor, page 47.
Yes, Lordship.
Very specific order. They'll continue to pay arrear and current
Yes, Lordship.
till a contrary decision is arrived at.
But nothing has been arrived at till now.
So why have you come now?
Lordship, there's no way out. What to do? She's a very powerful. They are
What do you
running
mean,
after
no way
officers
out?
that they are doing, Lordship. And some cases are considered hard case. When and from record, Lordship, like I had shown case 30.
Don't know, you
the
file
record.
contempt if it is not complied with.
This time is over, Lordship. Otherwise, we have to explain. This is the order.
You explain why, what delay was not there. Why should we keep on issuing writ? Writ is to be issued once.
That is true, Lordship. But the time is, that is a Lordship. This 2017 order. Now
What can be done? What can be done now?
ask them, let them ask them and take it instruction what the position is going on, why they have not taken any steps in present petitioner, Lordship. At
But
least,
why should we issue, even asking them will amount to issuing something?
yes, I'm leaving it to Lordship. Nothing, there's no alternative, Lordship.
No, there is an alternative. You have to think about it. There is an alternative. We are not foreclosing your reliefs. There is an alternative. Well, we can't tell you that. It is for you as a council to think.
As a Lordship, my little knowledge, Lordship, I did not find any scope.
You have to
approach this honorable court.
You have to approach people with greater knowledge. You approach.
Now,
you think about it. We'll take it up after 1 or 2 days. You think? We can't issue writs like this. Once a writ is issued, it has to be complied.
now, Lordship, true Lordship, the contempt I cannot file. That is 2017, Lordship.
You think about it and tell us on Friday, not on Friday. You think and tell us.
Next Monday.
Next Monday. What has been next Monday? Huh? Fourth. Based on 4th.
Yes, sir.
You think and tell us. We are not saying anything.
Yes, sir.
At the request of learned counsel for the petitioner, matter stands adjourned. To be listed again on 4th. MSS score appears for the Education Department. Yes, you are Mr. Borpuzari for finance. Mr. Medi for accountant. Accountant general. Yes, Mr. Gotoki.
May please order, sir. This is the before Lordship, my lord. He was the cashier of Department of Director of Veterinary Matter. And what happened, a criminal case was lost against him for embezzlement of fund. And in the criminal case, he was subsequently acquitted. Simultaneously, there was a departmental proceeding. In a criminal proceeding, penalty was imposed regarding withdrawal of gratuity. And that we have challenged that departmental proceeding on the ground that the inquiry officer is not coercive. Ultimately, this court set aside the department and the inquiry report and directed for de novo inquiry by appointing a new inquiry. But they did not comply with the order. And they kept the matter pending. And we again came, my lord, and this honorable court, your lords will find the order, my lord. That relevant page 63, my lord. That starts from 61, my lord, and lecture 13 in WBC number 1476. And the order dated 25/11/2022. That
yes.
There your lordship will find to on next page, my lord. Paragraph 5, my lord. Without going into the question whether de novo inquiry proceeding can be initiated, we take note that petitioner retired from service in the year 2012. Rule 21 of the Assam so and so provides for after retirement a disciplinary proceeding can be initiated only in respect of such allegation that took place within a period of 4 years prior to such proceeding. And as the period of 4 years is admittedly over, and the petitioner retired in the year 2012, it is now 2020, we have a view that any such intending this disciplinary proceeding against the petitioner would be barred under Rule 21 of the rules. Meaning thereby we have to understand petitioner retired from service without there being any disciplinary proceeding or order of penalty against him. That aspect of matter would be also due consideration regarding the regularization of period of service of the petitioner. In view of the matter under the law, although the petitioner may have been suspended, this is not a situation that he was not in service, so as to take away the period of service, but a suspended period was counting the qualifying period of the pension. Accordingly, responding director process the pension of the petitioner as per law and bring same to the logical convenient period from date of receipt of the certified copy of the order. So accordingly, what has happened, my lord? The authority, my lord, passed an order that you will also find at page 67, my lord. That is director in charge, my lord.
Yes.
What has happened, they have, after careful consideration on the relevant records, in compliance of the honorable court's order dated so and so, by comment letter number 20, the pension petition will be processed at the 20. So pension was given and the period of suspension was taken for purpose of pensionment. But but this was not regularized, and this pension and the back wages were not paid to me. That is the difficulty. That is why I moved to your lordship. So my representation, my lord, several representations, but because that was not regularized.
Yes. We'll issue notice at this stage.
Yes, that
Right?
notice will
Learned counsel for the parties issue notice to Honorable Porvik. MS8 Talukdar. Learned counsel appears for all the respondents.
Yes, all the respondents.
All the respondents. Since learned counsel represents the respondents, notices are waived. However, extra copies be furnished within a period of 1 week from today. Let the respondents obtain the required instructions as to why what is your prayer now? Area.
Prayer for this by suspension period, that should be regularized and it should be and the back wages, my lord, for that period.
The area salary for the period which the petitioner was put under suspension
That is
has
24.
not been released, and as to why the period of suspension has not been regularized in spite of the same, in spite of the said period being taken into account for release of the pension. Let the matter be listed after the return of the date. Yes.
May please. In this case, Your Lordship, I have challenged that input transfer order.
You have not arrayed the respondent number 5 by name. There is a specific allegation. Respondent 6.
6, yeah.
You have to array the by name. There is a specific allegation.
Allegation is there. So to this, I file a case.
All right. Mr. S. Islam, learned counsel for the writ petitioner, prays for and is permitted to withdraw the writ petition with liberty to file a fresh writ petition. Accordingly stands dismissed on withdrawal.
Publish.
Yes.
So the mostly similar petitions, petitioners hereby were promoted to the post of statistical officers. And my lord, their promotion came under challenge in another writ petition, which lordship will find the orders passed in the other writ petition is at page 25. Here, my lord, this honorable court.
You are for the petitioner.
I am for the petition. At page 28, lordship will find in another writ petition the
28 of 4088.
4085 I was holding, I have 4085.
4085.
4088 will also be. Page 28, madam. Of 4088. Sorry. That will be page 4029, madam. Lordship will find the second last paragraph of the order. Any promotion made in favor of the respondent shall be subject to the result of the writ petition. Our promotions to the post of statistical officers was challenged, and this was the order. My lord, we had already joined by the time this order had been passed, and therefore we were serving as statistical officers on that day. When we were not being paid our salary, my lord, or at the pay scale of the statistical officers, at page 35 we had moved an IA. This is the order, my lord. Lordship will find at page 35. The second paragraph, may I read, madam? The IA has been filed with the prayer to modify the order dated 2110 plenary passed by the learned single judge in so and so, whereby it is observed that any promotion given to the respondents will be subject to the final outcome of the writ petition. The appellants herein were implemented as 14 to 17 in the connected writ petition. Mr. Mazumdar submits that although the challenge writ petition is a promotion to the respondents number 6 to 8, yet due to the pendency of the writ petition, the order dated so and so.
You've been given a liberty to file a fresh.
Fresh matter on the next page. Now, this is the fresh writ petition. If lordships would have the order dated 26/7/2023 passed in this writ petition.
20?
6/7/2023, my lord, the first order.
Yes.
Lordship finds, Lordship would find at para 8, my lord.
Yes.
They were required to come up with the instructions why I was not being paid my salary on that rate, and my lord, it was also held that pendency would not be a bar. In the meantime, my lord, two private respondents who were repetitioners in the earlier repetition have got themselves included in this repetition also.
Hmm.
Now, my lord, the difficulty is in this order of 26/7/2023. Notice was not issued, only instructions were called for. Now, my lord, all the respondents are represented, the private respondents are here. If the notice is, my lord, deemed to be complete on all of them, my lord, in fact, my lord, I was praying for an interim order for release because of the judgments passed by the Honorable Supreme Court and the Dishonorable Court.
First, let us understand why salaries have not been
My lord.
released. Who's for the department?
We tend to file the affidavit from the commissioner. The
Well,
instructions are written.
you'll file, but first tell us why the salary has not been released. No
These people
instruction.
have now retired, my lord, their
Because-
pension is held up.
This is the instruction, Lordship, because they were treated as the post in the inspector of
No. Their limited prayer is that the promotions are made subject to outcome of the writ petition.
Lordship.
But they're already working. There is no denial of that fact. They're working as
In
in
the
the
same post, their
No.
salaries have been received.
We worked as statistical officers, they kept us paying the salary of the inspector.
But
And
still now
now
the
our
inspector-
pensions are even calculated on the post of inspector.
no. You are
They're
seeking
still the post of inspector,
No.
Lordship, because of the order dated 21/10, Lordship. Because the honorable court
And
interfered,
that has
Lordship.
been clarified in the last page order, my lord, that it is a misinterpretation.
you are
by the
seeking
Supreme Court.
promotion to which post?
We were promoted to the post of statistical officer,
From which post?
inspector, my lord.
Inspector of statistics
My lord,
to statistical officer.
officer. We joined.
You joined.
After our joining, there was an interim order of this honorable court that our promotions will be subject to outcome of the writ petition. We moved an I. This honorable court said there
So
is
that
no
now you're
restriction.
receiving salary in which scale of pay?
Inspector post, my lord, the earlier post.
So why the fresh current scale of pay is not being released?
Lordship, may kindly peruse the last paragraph of the I.
Okay.
IA?
Which I?
That was disposed of by,
Oh, yes.
in the earlier occasion, present institution has approached before this honorable court. And there was an observation, and whereby this honorable court has made it clear that during the, since the petition is pending for disposal, and till the further order lordship, when the petitioner will be released, the pensionary benefit as well as the salary in the scale pay of inspector of statistics.
That I was disposed of by this order.
But no modification is there.
That is with regard to
Lordship, they are
two of the
still
writ petitions.
considered as inspector of statistics, Lordship, because
And
Which was
Lordship,
disposed of
the
on this 10/5/23. It will culminate, my lord, on 10/5/23,
No. This is an order passed on 3/9.
my lord.
3/9/21. Passed
My
in
lord,
IA
that
1.
culminated in 10/5/23, my lord, in my eye.
One. Then the IAs were disposed of.
On 10/5/23, that interim order is of no consequence.
We are only asking you why it has not been released. We are not asking you there is a direction of the
because
court or
Lordship,
anything.
it is the post of inspector of statistics, Lordship, because the honorable court by order dated 21/10/2020, Lordship, it was clearly mentioned any promotion made in favor of the respondent shall be subject to the result of the writ petition.
Exactly.
So that writ petition is still pending, Lordship.
Correct.
And their promotions were interfered with till the outcome of that writ petition, Lordship. And that
No,
writ petition
interfered
is
by
pending.
which order? Which order?
21/10/2020, Lordship.
21/10,
WPC 4088, page number 29, Lordship.
Lordship will at page 29. What I read
29.
out.
It is only says promotion made in favor shall be subject to the outcome of the writ
Their
petition.
petition is pending, Lordship. This writ
Quite
petition is
right,
pending.
but why do you say that promotions were interfered with? They were not interfered.
No, no, that is pending. That's why they were still in the post of Inspector of Statistics, Lordship. They were
Okay,
never
I
promoted to
joined.
the statistical officer.
Lordship will have page 36, which clarifies that order.
No, do you have a joining letter or something?
Yes, my lord, we have all given.
That, Lordship,
The
the
joining letter we have not annexed, my lord. But it
No,
is
see,
next writ petition is pending,
19
Lordship. There has to be 10
if
of that
any writ
Lordship.
petition, if there is an order saying that it shall be subject to the outcome of the writ
Their
petition,
promotion, Lordship, yes.
their promotion does not mean that their promotions are suspended. There has to be a specific order that the order of promotion is stayed or will not be treated to be operative. The direction of the court that it shall be subject to the outcome is that notwithstanding their promotion in the higher post, the court may pass an order interfering with the promotion, remanding with them back to the feeder category.
But Lordship, I guess they are working as Inspector of Statistics, Lordship.
Let them come up, let them. sit
Why are
down
you
and-
guessing?
Instruction, Lordship.
Don't
says-
guess, you get your instructions.
Lordship, my instruction says there is flagman in the first page, Lordship. Because
These
of the order of the
instructions.
court, Lordship.
Yes.
Because of the order dated 21/10/2020.
They're somehow not posted with the current facts. They're referring to the earlier interim
That's
order.
why I wanted the updated instruction from the.
The
Commissioner
updated
Secretary,
instruction
Lordship.
is enclosed to the writ petition.
Hmm.
The I has been disposed of, directing them to, this is the page 35 is the updated instructions. They're referring to earlier instructions, earlier order, 2110. Standing counsel is in serious need of instructions. These instructions are not come clearly. You get your instructions. See, this 21, it is copy.
This I is
In
not a
fact, my lord,
modification of the earlier.
if
order,
lordship has ordered it
No,
26,
your instruction,
This I order is, Lordship, not a modification of the WPC order.
Correct,
dated
correct.
2010, Lordship.
it has clarified the same.
He had just said for a fresh writ petition, Lordship. That's why this writ petition.
that's right.
And in this writ petition, the respondents, Lordship.
No, correct.
They-
We agree with everything. We are only asking you that in view of this order of making it subject to the result of the writ petition, why their salaries have not been released? There is no stay of the promotion.
The earlier post salaries have been released, Lordship. They
No,
wanted
no,
the
promotion,
salary.
promotion.
That's what, Lordship. That instruction I have to take. Because they don't have
there
the
is no
joining letter
order.
with the promoted post,
No, but
Lordship.
there is no order suspending it. There is no order suspending it. The order rejecting the modification is rejection of the modification of the order dated 2110, isn't it?
Lordship. And
2110 says subject to outcome. That has been not allowed. But subject to outcome does not mean that their promotional posts are stayed or their salaries are to be withheld.
that salary part, Lordship, I guess they are getting, Lordship. That instruction I have to take.
He says he's
That's
not
why at the
getting.
very first instance,
We
Lordship,
retired
I
the
paid for
getting.
instruction.
Lordship has para 9 of the order dated 26.
Get your
the
instructions.
first-
Let us
The
see.
first order.
Para
Clearly,
9.
Para 9 of the order dated 26/7. Everything was taken into consideration, all these. Para 9 of that order. The first order, my lord, that was passed in this writ petition. In this writ petition, 26/7/20.
Yes, yes,
Para 9.
yes.
Pendency of this writ petition shall not be a bar for the respondent to pay the arrears of the petitioner on his promotion to the post of so and so in terms of notification 19/9/20 noted above, as well as the orders of the court dated 21/10/20 and 10/5/23.
And
These
para
have been
10,
taken, these have been taken into consideration.
and para 10 also says whatever salary has been received is conditional.
It's
to be
conditional.
recoverable.
Recoverable is tough, Lordship.
Para 10.
Yes, Lordship.
It is mentioned here. Get your instructions here. You can't withhold the salary unless there is an interim order. Unless you say that they have not joined. Unless you say that they're not working in the promoted post. Heard learned counsel for the parties, MS R. Bora, learned standing counsel. What department?
Agriculture department.
Huh?
Agriculture.
Agriculture. Submit that her instructions are not complete. And she'd like to, she prays for further time to complete her instructions on the aspect of why the, or in respect of release of salaries in area salary to the writ petitioner in their post of statistical officer, agriculture, which the petitioners claim that they have been promoted to and are working. All of them are working or retired?
Some of them are retired, my lord.
In which they are working or end of league or have retired in the meantime. Let the instructions be placed before the court by the next date fixed. Mr. D. Borua Sharma appears for the private respondents. What are your objections? You are challenging their promotion.
Seriously, I have not challenged the promotion. The first thing is that I have challenged the promotional notification and the decision of minutes of the selection committee, Lordship. Because there is a contrary between
It
the
is in
Lordship
your writ
service-
petition that the promotions were made subject to outcome.
Yes,
In your writ petition.
Yes, Your Lordship.
They are not listed today.
But in this present writ petition, Lordship, though the first order was passed by this honorable court, in this writ petitions, Lordship, I have not made party respondent, Lordship. And subsequently, I have been impleaded on the basis of the application
Now,
filed by
in
the.
this set of writ petitions, no notice is issued.
Notices were on
Notice
26/7, my lord.
that may be issued,
particular
Lordship,
word, my lord,
because
that
both the writ
issue notice
petition
was
can
not
be
there.
taken together and both the writ petition can
All
be
right,
disposed of by this honorable court, Lordship.
Heard no issue notice returnable 3 weeks. MS R. Bora appears for agriculture, Mr. Korpuzari for finance, MS K. Das for J. Das for accountant general, and 6 and 7.
Yes,
You're
Your Lordship.
appearing.
Yes, Your Lordship.
Mr. D. Sharma for 6 and 7. Yes. Accountant generals, you give the names. Accountant generals, you give the names, who is appearing in which matter. Issue notice returnable so and so. Since the learned standing councils represent the respondents, notices are waived, however, extra copies be furnished within 1 week from today. Let the matter be listed. Again, after 3 weeks. We'll have it in April,
Yes, sir.
3rd of April, along with the other WPCs. Give the numbers.
Yes, Your Lordship. That can be. both
Along
can
with
be-
WPC so and so so and so for admission.
WPC 4373 of 2020.
These are in the admission stage?
Yes, sir.
Those WPCs?
Yes, yes.
Okay. WPC 4373
73 of 2020.
of 2020. Only one WPC.
One WPC.
Along with WPC so and so. List accordingly.
All the writ petitions, my lord, he appears for the private respondent.
Yes, Your Lordship. Because I am the writ petitioner in the. writ petition-
That is just for the record, my lord, because the other orders may not carry it.
I have already included.
Private respondent and agriculture same. Only accountant general. Yes.
Obliged.
Highly obliged.
My pleasure. My lord, this case relates to the suspension of the petitioner, my lord. And
any instructions?
I have on record the draft charges which were already communicated to the petitioner on November 2020.
Draft charges.
Yes.
Charges will have to be final to be communicated.
Yes, but that is followed after an inquiry officer is appointed, and that has also been done.
Are you proceeding with the inquiry disciplinary proceedings? Then you have to give him charges, not draft charges. The charges, the authority will have to decide that these are the charges or allegations against the petitioner in which he is to give a reply. What is it exactly?
There is a show cause with charges given to the petitioner, and based on that, it has draft charge has been submitted to the head of the department. Once that is approved,
Yes,
that will become.
Mr. Gogoi, what is the draft charge concept? Some draft charges have been sent.
Draft charge is basically, my lord, it has to be signed, my lord.
By the head of the department.
Specific charge, my lord, because tomorrow there will be a ground, the charges are vague. And after that apart, my lord, his suspension has been reviewed twice.
No. Have the disciplinary proceedings been initiated?
Initiated, my lord, inquiry
Yes,
officer has
inquiry
been
officer has-
appointed, my lord.
Then
Everything of
why
it
the
is-
draft charges? Why the draft charges?
The draft charges part is gone, my lord. It's way back in November, my lord. It's been finalized and so, consequent to that, my lord, condition is.
No, have the charges been issued?
Frame, my lord.
Framed.
Yes, my lord. It was he is taking a instruction of November, my lord. And the place I'm relying, my lord, in placing it's of February, my lord. Draft charges has been finalized, charges have been put, my lord, specific. Now inquiry officer have been appointed, my lord. And my lord, he has been show cause way back in 10/10/23. And regarding, my lord,
Have you seen this? You see this?
My lord, this, my lord, it was not
No,
served
no, it
upon
was
me,
served.
my lord.
It was served.
And apart from that, my lord, draft charge, my lord, resubmission.
You go through this 17-2.
and that about, my lord, there is an annexure to his petition which says he has
17.
represented, my lord. That I stoutly deny, my lord. We are not in receipt of this kind of representation.
Sir, suspension has been reviewed.
Yes, my lord, twice. List of witnesses is there, my lord. Charges are there.
My lord, I feel, my lord, if they have reviewed, my lord, then question will otherwise will come, my lord. Let them produce the record, my lord, tomorrow, day after tomorrow.
Where is the review order?
The review
Suspension,
order is
review of the
there, my
suspension.
lord. This totally silent, my lord, in the both of them.
Then I can
Heard-
definitely bring, my lord.
Heard learned counsel for the parties, it is submitted on behalf of the Forest Department that the disciplinary proceeding has been initiated by serving a show cause notice on the writ petitioner. That apart, the inquiry officer as well as the presenting officer has been appointed by order dated 17-2,
17 to
2024.
appointment of inquiry officer, but I'm not aware, my lord, no show cause,
No, he
nothing.
doesn't-
No, it's there.
This is 17 to.
17-2. Stop. The further submission is that the suspension of the writ petitioner has also been reviewed twice. However, the copies of the orders are not placed before the court. Where Mr. Bormia, learned counsel for the petitioner, however, disputes the submissions made by the standing counsel, submits that no show cause notice, etc., has been served on the petitioner.
No
And
review
that
also.
apart, no review of the suspension was carried out to the best of the knowledge of the writ petitioner. Thus, under such circumstances, let the respondents place before the court the relevant records or the orders, place before the court the relevant orders by which the suspension was reviewed. And if such orders are not available, then the relevant records which reflect that review of the suspension was carried out.
Right.
Stop. The respondents are also at liberty to update, to place before the court the status of the
Right.
disciplinary proceeding, stated to have been initiated against the petition. Let the matter be listed on 13th March.
My lord. Can it be, my lord, on 6th, my lord? Because I'm now nothing else. 6th of March.
6th of March.
All right.
Here I took time on the last occasion to inquire about the status of the criminal case, my lord. That has ended in final report, my lord. Now, my lord, the petitioner, my lord, the amount what is due, my lord, that will be paid to her, my lord.
Amount due will be paid to her.
Yes. Bottom mark.
What is the amount due?
I have not received any sanction order, Lordship. Gratuity, leave salary, and CPF, Lordship. Those are the amount I have to receive, Lordship. But till date, they have not given me the sanction order also. Return in the year 2016, Lordship.
She is entitled to an interest.
That was not being paid because of the pendency of the.
When was it? When was the FR submitted?
It is in the month of December 2023.
Then we are in the middle of February.
29/12/2023.
End of February. Heard learned counsel for the parties. It is submitted by Mr. Munir, learned standing counsel, Assam Khadi and Village Industries Board, that the criminal proceedings pending against the petitioner ended in a final report. And as
FR
such,
number 2128.
being FR number
2128 of 2023.
2128 of 2023, which was submitted in
Dated 29/12/2023.
29/12/2023, which was submitted in which case?
Sanmari Police Station case number 549 of 2007.
Chanmari, in connection to Chanmari Police Station case number
549
549 of
2017.
2017. Stop. It is submitted that in view of the submission of the final report in the criminal matter, criminal proceedings, the authorities are now considering the claims of the writ petitioner towards settlement of her leave salary,
Gratuity and contributory provident fund.
gratuity, and contributory provident fund. Stop. Learned counsel prays for further time to apprise the court with regard to the decision of the board regarding the claims raised by the writ petitioner. Para. MSP Bhattacharya, learned counsel, Bhattacharya, learned counsel for the petitioner, submits that till date no sanction order for the amount prayed for has been issued by the authorities. Para. Let the matter be listed after 2 weeks, by which date the respondent authorities will furnish the sanction order, furnish the decision and the sanction order in respect of payment of the arrears as claimed for by the writ petitioner. List on 13 March.
Obliged.
May I please your Lordship? Lordship, my senior legs on court number 4, so matter may be possible for time.
We pass it over for the day. It is submitted that the counsel for the petitioner is not available. Therefore, the matter stands passed over for the day. Yes. Anyone for the respondents? MSR Bora for Agriculture University Department. MS A Talukdar for which department? Pension department. Yes. Mr. R.K. Talukdar appears on behalf of the Accountant General. R.K. Talukdar for 7. There is no respondent 7.
Five. Okay.
Then both of you sort out who is appearing for whom. Sort out. We are recording the name of R.K. Talukdar. Okay. R.K. Talukdar for respondent number 4. And who's for 5? That will be respondent number, Department of Agriculture,
Lordship, I am available.
R. Bora, then A. Talukdar for respondent 2 and 5. R. Bora for 1 and 3. And R.K. Talukdar for respondent 4. Next week, yes.
Please, my lord. My lord, here the grievances of the petitioner appear to have been met, my lord. But your lordship may quickly allow me 1 week's time to obtain proper instruction.
It is submitted that by the learned counsel for the petitioner that the grievances of the writ petitioner have been redressed. However, he prays for a week's time. If you say it is redressed, we close it. Why a week's time?
Lordship,
For what
just,
purpose?
if anything remains, lordship, I'll just obtain those.
To obtain the instructions from the writ petitioner, Mr. P. Kotoki, FES for respondents 1 to 4. Grievances for non-supply of the inquiry report.
Lordship, and
Not supply. Actually, he was not getting his salary.
salary also is there.
Posting, everything was gone. Now he is
Transfer also has been as per
Okay.
affidavit done.
Okay. After 1 week.
Most of them.
Case, my lord, by order dated 4 to 2022, notice was issued, my lord. Until today, they did not file any affidavit, my lord.
Yes, Mr.
Lordship, I received instruction, Lordship. She will file our affidavit, Lordship. We are not to-
Mr. P. N. Bora appears for the writ petitioner, Mr. P. N. Bora. P. N. Sharma, learned standing counsel, elemental services. Instructions have been received. We'd like to file an affidavit list after 3 weeks.
But it's a date, my lord.
1st of April.
My lord.
Lordship, with regard to the Lordship will find in the first page, Lordship, with regard to the provisional pension, it has been sanctioned on last Friday. Lordship, within a few days, it will be credited to her account. And Lordship, with regard to the refixation as directed by the Director of Pension, Lordship, the IS has received the statement from the school authorities. And within a day or two, or maybe already sent Lordship today, it will be sent.
Right.
Lordship may take it up after 2 weeks. Lordship, in
Yes.
the meantime, the progress.
None appears for the writ petitioner, Mr. B. Chaudhary, learned standing counsel, BTC.
Yes, my.
Submits that the provisional pension has already been sanctioned and the petitioner is likely to receive within a day or two. And what is the other prayer?
Other prayer, Lordship, as directed by the Director of Pension for refixation of our pay scale, there was overdrawal. That formality is also, Lordship, received from the school authorities. The IS is going to send it within a today or Lordship tomorrow. Lordship.
It is further submitted that the steps have been initiated for resubmission of the pension proposal in favor of the writ petitioner after making necessary changes as required from the Office of the Accountant General. Mr. Boro appears for 7 and 8. Who is 7 and 8?
School authority.
appears for respondents 7 and 8, and MS counsel for appears for 1, 1, 1, 4 and 1, 4 and 6. Matter be listed after 2 weeks. Yes, Mr. Monroe.
My lord, as for the last order, my lord, direction was given to, my lord, apprise the code, whether my lord, the inquiry report that was served to me or not, my lord.
Lordship, no inquiry report was served. There is no record of serving the inquiry report to the petitioner. And even the lordship has directed to produce the proceeding record, lordship. Even that proceeding record is also not available, lordship. I have instruction, lordship.
Give us that instruction. Not available.
Not available.
In digital. In
Just
digital
now
mode.
I received the WhatsApp message, lordship. It says, lordship, as per the office record, the inquiry committee has submitted only the inquiry report to this office on 22nd November 2019, duly signed by the inquiry officer and the presenting officer, with a forwarding letter signed by the inquiry officer, Srimati Boni Thakur, the then Deputy Inspector of Schools, Margarita. And secondly, on the other hand, there is no record in this office regarding handing over the inquiry report to the inquiry report of the inquiry committee.
Who has issued that instruction?
This instruction is issued by the District Elementary Education Officer, Kinshukya, lordship.
Now, what steps have been taken after the inquiry report?
You are reinstated as per the, my lord, the proposal given by the inquiry committee, my lord. That is, I annex page 34, 39, my lord.
With stoppage of one increment, lordship.
And they suggest that one increment should be stopped. And on the basis of that, I was reinstated, and subsequently that period was also regularized. But while the regulation was done, there is still the one increment to be stopped. That is in continuing.
Petition has already been reinstated. Only question is that stoppage of one increment.
And my suspension period was also never approved.
Who is the appellate authority?
Appellate authority, my lord, that might be the commission.
You filed an appeal.
But the thing is that my earlier occasion also, lordship, my lord, seeing the, my lord, situation, because the long time has gone. So, my lord, considering that aspect, my lord, they decided to take the matter here, my lord. And moreover, but the petitioner is going to verge of the retirement. So, my lord, everything is.
Then we'll need their affidavit. We must have this information on the affidavit that no inquiry report was served on you. Or the records must reveal. Do you have the records?
Yeah, I have the records on the last.
Record was last occasion it was produced.
There is no proceeding record, lordship.
That is but the same thing. Whatever.
There is only the finding of the inquiry committee.
That is the same thing, but I annex in page 39.
Record is there, lordship. There is no proceeding record, lordship.
Same thing I annex, my lord, 39 page. And moreover, my suspension period, that was not, my lord, approved by the authority concerned. I was continuing in suspension without any approval, and subsequently I was reinstated without approval. Approval come later on, after reinstatement to the service.
It has been regularized.
Regularized, my lord.
As on duty.
As on duty. Approval of the suspension, that is also come after reinstatement. That is a more than 8 and
Who is the authority who is your disciplinary authority?
You know, the director.
Director.
Yes. It is the last order that is come from the director. It is annexer page at 50, annexer 17. By whose melody, entire melody that period is gone, but the only the things is I impugn by the melody regarding the melody one increment that has been stoppage of one grievance is continued. I paid that melody, this entire melody procedure that was visited with all the provisions of law. Disciplinary appeal rule was not followed. Nothing was done. So this order should be, my lord, set aside and.
Some affidavit is required. Why don't you bring in record, whatever stand you want? You give them 1 week's time.
My lord, yes, sorry.
You file your affidavit.
Lost.
Third learned counsel for the parties, Mr. B. N. Sharma, committed a week's time.
10 days time.
All right, 2 weeks' time to
Yes.
complete his instructions
Yes.
and to file an affidavit as it is submitted that instructions have been received in the
Yes.
matter.
Yes.
Let the affidavit be filed within the period of 2 weeks. Matter be listed again. On 18, 19.
18 is, I think, is a holiday, my lord.
Hmm?
19 maybe, my lord.
18 is a holiday.
It is.
No. It's a restricted holiday.
All right, my lord. So 18, my lord.
18th. Listed on 18th.
Master.
May I
Yes.
please, Your Lordship? Kindly see order dated 2/2/2024.
Hmm.
Lordship, we have received our instruction, Lordship.
What instructions?
Our Lordship,
Some document was required to be furnished.
Lordship, the petitioner has herself submitted a prayer, Lordship, stating that she has applied to concerned authority for issuance of the relevant documents. Some time, Lordship. The last para of the instruction. Annexure 5 is a letter, Lordship.
What documents were sought for?
Lordship, that are to be enforced along with the application, Lordship. Relating that she is an unmarried dependent daughter, Lordship.
You have applied to the authorities for some documents.
My lord, I have to take instructions from my client regarding the recent update.
At the request of learned counsel for the writ petitioner, matter stand adjourned for 2 weeks. MSA Talukdar appears for the state.
Lordship.
Mr. B. Chakraborty for respondent 5. After 2 weeks. Yes. You can take back the instructions.
Your life.
Please, your lordship. Lordship, kindly go through the order dated 29/1, my lord. Instruction was sought for from the Amgori Municipal Board.
Yes, who's for the respondent?
My lord, in the meantime, on development, my lord, I have filed a miscase, my lord.
Hmm.
They have passed an order on 5/2/2024 in miscase paragraph page 13, annexure 10, my lord.
You have been reinstated.
Reinstated, but from the from 6/2/2024. And who is post? What is my post?
You reinstated as whatever you were. What were you? Tax daroga.
Yes, assistant
You
tax daroga.
reinstated as tax daroga.
No, my lord, as an employee of the.
As an employee, you reinstated means you are brought back to the post which
And
you were.
from my lord 6/2 only.
Oh,
How that can be possible, my lord? I have been suspended on 2017, 27/1/2021. The gap period, my seniority, everything will go now.
Then you have to. Why are you filing a miscase?
Because to brought this document in the record, man.
You file a fresh case.
That I will
This
file.
is a new cause of action. If you are aggrieved.
Yes, definitely, I am aggrieved, my lord, by this order.
If you are aggrieved, then it is a new cause of action. Bring a fresh writ petition.
But the problem is they have Amguri Municipal Board, neither they appear nor they file any affidavit, only government advocate help us.
No, what? How does that prevent you from filing a fresh writ petition?
No, fresh I will file mail. But in this petition, my subsistence allowance are also paid there, man.
We'll consider that.
Yes, that may be.
But as on date, you are
Reinstated.
Reinstated.
Yes.
But you bring it on record.
Yes.
You withdraw this IA and file a fresh writ petition.
Yeah, the liberty may be granted. Yes.
Third learned counsel for the parties. This is an IA. IA, so the petitioner has approached his court by filing the connected writ petition, praying for direction. To set aside the discharge order dated 24/3/2020 issued by the chairman Amguri Municipal Board, and a further direction to reinstate the writ petition. Stop. During the pendency of the writ petition, an order dated 5/2/2024 was issued by the executive officer Amguri Municipal Board, whereby the petitioner was reinstated as an employee of Amguri Board with effect from 6/2/2024. Stop. This, according to the writ petitioner applicant, is an order which does not comply with the earlier orders passed by the court, whereby the petitioner was asked to be reinstated in his earlier post as tax daroga.
Assistant tax.
Huh?
Assistant tax daroga.
Assistant tax daroga. Learned counsel for the applicant writ petitioner submits that this order merely reflects that he is reinstated as an employee of the Amguri Municipal Board. That too with effect from 6/2/2024. Therefore, the IA has been filed, praying for necessary orders. During the course of the argument, Mr. Roman, however, sought liberty of the court to file a fresh writ petition assailing the impugned order dated 5/2/2024, as well as the arrear benefits not yet released in respect of the writ petition. Para. MS A. Talukdar appears for the respondents. In view
For 1 and 2.
only for 1 and 2. In view of such submissions, the IA stands closed, giving liberty to the writ petitioner to file a fresh to file a writ petition assailing the order dated 5/2/2024 as it is a fresh course of action. I accordingly stands disposed of in terms of the above. Then in WPC so and so, in view of the I so and so, now what to do with this writ petition?
My lord, this petition,
We'll defer it. You file the fresh writ petition, we'll take it up together.
yes, sir.
Matter be deferred by another 2 weeks, enabling the writ petitioner to file a fresh writ petition as prayed for and is reflected in the order dated so and so, passed in IA so and so, and apprise the court whether any grievances still remains to be addressed in WPC 6028. Stop. Copy of the order dated so and so, passed in IA so and so, be retained in WPC 6028. Matter be listed after 2 weeks. MSA Talukdar for respondent 1 and 2.
My lord, in this matter, we are yet to receive the instructions, your lordship. So
The petitioner was retired on 31/8/2021, Lordship. Thereafter, by the impugn later dated case 20, Lordship directed the department to resubmit the proposal. And accordingly, they have resubmitted on 35/2022, case 22.
Yes.
Till date, full and final pension has not been.
How much time do you require
10
for
days, your
instructions?
lordship. 10 days, your lordship.
The last 2 occasions also they have same prayer, Lordship. Lordship may fix the date.
Several occasions have been,
Yes, sir.
several opportunities granted. Mr. K. Kolita appears for the writ petitioner, MS
Which
Therapy appears for the
Oh, 1 and
1 and 2.
lordship.
1 and 2,
Yes, your lordship.
who submits that
1, 2, 3 also, your lordship.
1, 2, 3, her instructions are not completed. It is seen that several opportunities were granted to the respondents to obtain required instructions. In the interest of justice, further 2 weeks' time is granted to the respondent education department, elementary education. No, what is
Secondary, your
that?
lordship.
Secondary education department to obtain the instructions with regard to non-release of the pension, the writ petition. Matter be listed after 2 weeks.
May I pray for a date, Lord?
Mr. B. Chakraborty appears for Accountant General. List on 3rd of April.
Obliged.
The notice was issued in this case.
Here I am appearing for the respondent. In fact, I have been newly engaged, my lord, to represent this university. I am praying for 4 weeks' time to file affidavit.
Okay, may I pray for a date, Your Lord? Is it related to EPF, Lord? Or EPF was illegally and arbitrarily cut off?
Third learned counsel for the parties, Mr. M. N. Nath, learned counsel, appears as entered appearance on behalf of respondent 4.
All
respondents. All respondents. He prays for 4 weeks' time to file his response. Let the matter be listed after 4 weeks. You may like to file a rejoinder after that.
Lord.
So why fix a date? Let him file the affidavit first. After 4 weeks.
Please, my lord. My lord, herein is a case of recovery of 4,55,100 rupees from an employee who has retired from service. The petitioner served as a library bearer at Murkong Select College, and recovery of 4,55,100 was made from his DCRG, which was an amount of 6,15,000. So less than 1,50,000 has been received by him. And your lordship, In this regard, the law has been laid down by the Honorable Supreme Court in Rafik Masih case, Your Lordship.
That was prior to deduction. Do you admit that it is a wrong fixation?
Yes, Your Lordship. That is also a part of their communication at page number 31.
But the amount has already been deducted.
Yes, my lord.
Yes, who's for the respondents?
For the respondent number 1 and 5, Lordship, I'll have to obtain my inspection, Lordship. I'm not received any inspection.
Rafik is prior to deduction. Just before deduction.
But Your Lordship, they deducted immediately. It was done, Your Lordship. They deducted it from my DCRG, Your Lordship. The DCRG amount paid to me was after deduction.
You are not disputing this amount. You are admitting that this is a wrong fixation.
Lordship.
This is not entitled to you. You are not entitled to this.
Lordship.
Ordinarily, you are not entitled to this.
But it was not on account of my fault.
Maybe, but the amount has already been deducted. Now your prayer is for refund of that amount,
Lordship.
which you are not entitled to.
No, my lord, that is completely barred. They could not have done it. There is also a notification of the state government. I have annexed that notification at page 41. My lord.
But the problem is that you did not approach the court at the time of deduction.
My lord, there is another case, similar case, my lord, where such a deduction had been made and the honorable court directed recovery, repaying, refund of the money, my lord. If your lordship may kindly produce this one.
No, I agree with everything, but what I'm trying to ask you is this law is in respect of stoppage of or prevention of any deduction where it is found that certain amount has been wrongly paid to you. There is no recovery. Here is a case where the recovery has already been made.
That happened in a very short span of time, my lord.
What does the state government notification say?
My lord, this was the state government notification at page number 41 was passed after the Honorable Supreme Court's order in Rafik Masih. And thereafter, these situations where the state government cannot effect recovery of pay was laid down, my lord. One of the criteria is recovery from employees belonging to class 3 and class 4 service. And also, my lord, second category is recovery from retired employees or employees who are due to retire within 1 year of the order of recovery. So, my lord, recovery from me, I am also a grade 3 employee, and also the recovery was made after my
What is the amount of recovery?
4,55,100.
So under the notification, it is only to a financial shilling of 1 lakh. Page number 42, para 9.
It's a waiver of recovery, my lord.
That's right. Waiver of recovery. This is all about waiver of recovery. See, you are not entitled to that amount. You admit.
Lord.
It is not your case that there is a question of finding out the fixation of pay, ceiling or scale of pay. You are admitting that this is not an amount you are entitled to. As per Rafik Masih, ought not to have been done, but it was done. Now you're before this court asking for a mandamus to the government to refund you an amount which you admit that you're not entitled to.
Lordship, because please kindly consider the hardship faced by the...
What hardship?
Yes.
Ordinarily, you are not entitled to. You are entitled to X amount of salary. You received X plus 1. Ordinarily, you would have received X amount of salary. Somebody else rightly may have received X+1 salary at a higher scale. Will you say that it causes hardship to you? No, you're receiving the salary entitled. But by oversight, by mistake, X+1 was credited to your account. Now that +1 has been removed. You are before this court saying that this +1 you are entitled to in view of this law.
But in that case, your lordship, if I may humbly submit, if I may humbly
We'll
submit
examine
to-
that. We'll examine it. But subject to correction, unless you are questioning the fixation itself, you have to question that, yes, no, there's no wrong fixation. Amount you have received is a correct amount.
But they could have only recovered before 1 year of my retirement. Lord.
They could have done anything. You are the employee. You know what scale of pay you are receiving.
My lord,
For how many years?
1996, my lord, and I retired in 2022 for 26 years, my lord.
You have been receiving wrong scale of pay.
My lord, the fixation was done by them, my lord. So I was not aware. Only after they communicated this after my retirement, it came to my knowledge, my lord. For the first time, the communication was made on 4th of August 2022, my lord. At page number 31.
Big market. Huh?
That's para 18, my lord.
Yes, what do you say?
Lordship, in this case, Lordship, respondent number 234 instruction is also required because Lordship, they seeking for a direction to the accountant general to make the payment, Lordship. So their affidavit is also required, and principal has also not been.
No, before that, you tell us the application of the law that you are aware of. It doesn't require instructions. You examine and tell us.
Yes, Lord.
What was the direction in this Rafiq Mashi finally?
My lord, in paragraph 18 is the final direction.
These are the principles
Yes,
laid
my
down.
lord. In which circumstances recovery would be impermissible? If I may read, my lord.
Yes, we've seen it.
May I read, my lord?
Let them get their instructions. We'll see.
Lordship.
Matter be listed after 2 weeks, enabling the respondents to complete their instructions. In respect of the recovery made from the petitioner on account of wrong fixation of pay.
Yes, Lord.
Wrong fixation of pay to the what is the amount recovered?
4,55,100 rupees.
4,55,100 during his service period as library bearer of Moorcock Select College in Chennai. Learned counsel for the writ petitioner has relied upon the judgment of the apex court rendered in Rafiq Mashi, reported in so and so, as well as a judgment of the coordinate bench of this court in dated 3/4/2023, passed in WPC 719 of 2023. Matter be listed again after 2 weeks.
Would it be feasible to fix a date, my lord?
3rd of April.
3rd of Obliged, my lord.
My lord, in this writ petition, they have not taken any action. If you, lordship may kindly see last days of the 25. They have not done anything.
My lord, we have taken.
Neither the subsistence allowance is given, nor the entire area repair for at least long 3 years. How the petitioner will remain alive?
Why have you not paid the subsistence allowance?
My lord, we have already taken steps, my lord. I'm appearing on behalf of this MD Bora, my lord. For the arrears salary, we have already written. We have
Subsistence allowance.
Subsistence allowance, my lord, there is no agreement to that, my lord. The subsistence allowance has not been paid. They have only paid for release of arrears salary.
So what is the status of arrears
My
allowance?
lord, on the last day we had submitted, my lord, that it is being the period for which they have taken medical leave has been regularized, and the matter is under process, my lord. I have taken instruction today as well.
Process before whom?
My lord, I have one instruction. It has been written from the registrar to the government, and I have communicated with the joint secretary also, my lord. They have said that it will take some time. It is being processed. for the release of the salary.
You did not receive your subsistence allowance.
Nothing.
Have you made a statement here in the petition?
Yes, nothing. A clear direction is necessary to make the payment.
Where is that ever meant that you have not received subsistence allowance?
I know this page number 26 of the order of reinstatement.
Yes.
Hello, it says the 4 points. Since the charges level against the charged official have been substantiated, the DP against him is concluded as follows. The period of unauthorized leave from such and such may be regularized by way of granting leave as applicable, subject to availability of leave in his credit and subject to submission of leave application. While we are taking medical leave, he was asked to produce the medical certificate, but thereafter, my lord, may see the last order, we had regularized his leave against the medical leave, my lord. And now therefore it is under process.
How much time do you require?
Well, 3 weeks may be given, my lord, by then the department will process a date may be fixed.
There is no prayer for subsistence allowance. It's only for area salary.
No, but yes, but that is one. But areas subsistence allowance is also not paid, even though.
But you have not pleaded here specifically. We'll give him some time, let him apprise the court on.
Already more than very good time is given. A clear direction is decided within 2 weeks time. 2 weeks time, not 3 weeks. 2 weeks time is they may be.
You complete the you complete the instructions because the court has given sufficient time.
No, my lord, on 21, 24, my lord, the issue was whether the medical certificate he had not submitted, my lord.
We
So
don't
there-
know, but the petition
My lord,
notice was issued on 11/4.
my lord, it was issued.
Then
Therefore, my lord, initially the problem was that he had not submitted the medical
whatever the
certificate.
problem may be, now the problems are
Yes,
clear.
on
You
21
take a decision
My lord.
and comply with the order.
My lord, my lord.
Let the matter be listed again on 3rd of April, by which date the respondents will apprise the court as to the status of the release of the area salary or the period the petitioner was considered to be on unauthorized leave, being 23/8/2018.
Yes, my lord,
4/10.
4/10/2018.
24 or 4?
4, my lord.
4/10/2018. By granting leave salary in view of the decision already taken by the District Deputy Registrar of Cooperative Societies, ID order dated 2nd July 2022. Mr. Mehdi appears for the writ petitioner. It is made clear that if the respondents are unable to apprise the court as to the specific orders required to be passed by the department, court may consider passing consequential orders in the matter.
Next date,
3rd April.
Too late.
Too late. You want it earlier?
Earlier.
My lord, in between we will take
15 March, 15 March or 16 March.
15 March.
that will be a little longer. Otherwise,
All right, 15 March.
Yeah.
15 March. List on 15 March.
Lordship, here I prefer some accommodation, Lordship, although the director has already instructed the DO to send the first proposal, Lordship, area selling proposal along with the report, Lordship. So that instruction, once that received, the process.
Yes, any objection?
Date may be fixed.
Mr. P.N. Sharma, Learned Counsel, appearing for the respondents, prays for further time, complete his instructions. Mr. Richard Ahmed, Learned Counsel for the petitioner, does not object. However, he prays for a fixed date for the matter to be listed. Accordingly, let the matter be listed again on 3rd of April.
Lordship.
May I please the lordship, my lord. Instruction was called for in the last order.
Yes.
My lord, we have returned the original service book of the petitioner, my lord, on 25/1/2024.
You have returned the service book.
Service book, my lord, to the concerned administrative department. Now they can proceed, my lord.
Who is the administrative department?
Administrative department is secondary education department.
Who's for secondary education?
Sorry, elementary.
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 Elementary education. It is submitted by Mr. P. Soikia, Learned Counsel, appearing for the Director of Pensions, that the original service book has been returned back
My lord.
to the administrative department, namely the Department of Elementary Education.
My lord.
Why have you returned it?
No, my lord, original, we have already released the pension of the petitioner. Some CPF amount due to the petitioner, my lord. Therefore, original service books is required, my lord.
We have
for the purpose of release of CPF,
my lord. MSCP, my lord.
MSCP
MSCP.
by the department.
My lord. Yes.
Stop. MSS Sworn Learned Standing Council, Elementary Education, submits that she will obtain her instructions in the matter and prays for 2 weeks' time. And yes, who else are appearing? J. Das for Accountant General, Mr. R. Borpuzari for Finance, Respondent 3 and 8. Anyone else? And Mr. M. Hussain appears.
M. Islam.
M.
Islam.
Islamic, the writ petitioner. Matter be listed again after 3 weeks.
Date may be
3rd April.
Online. Online.
He has submitted the inquiry report, lordship. And inquiry officer, lordship, has defined that the petitioner is entitled for pensionary benefit, lordship. So, lordship, my humble submission is that, lordship, the authorities may be directed for sanction and the release order, lordship.
So first tell us what is the facts of your case.
Lordship.
Why your pension has not been released?
Lordship, comprehensive lordship statement has been made in the lordship inquiry report, lordship.
Your pension has not been released.
Yes, lordship.
Why?
Ground is that lordship regarding the lordship confusion regarding the merits, lordship. Between the petitioner and her husband, lordship.
Husband expired.
Yes, lordship. Husband.
So you are asking for family pension.
Yes, lordship.
Ah. Now what does the report indicate finally?
Lordship, kindly see page 150, last para, lordship. Inquiry report, lordship.
150.
No. Huh? Yes, ma'am. Lordship,
What is the finally? What is
last
the
page.
finally conclusion?
Last
Favor of petitioner, yes, sir. The report is in favor of petitioner. In favor of petitioner.
In favor of petitioner.
No. As per DC reported. Conclusion.
So you release the pension? You have got a copy of the report?
Lordship, my friend.
Third learned counsel for the parties, the claim of the writ petitioner for release of family pension. Respect of the services rendered by one Sukumar Polita, who served as assistant teacher, stipendary, in 1250 number, Tukurakuchi LP School, and subsequently was allowed to hold charge as headmaster of 689 number Omrar Tari LPC. So, the husband of the petitioner expired during service on 27/6/2021. Stop. Is the claim of the petitioner that she, being the legally wedded wife, she is entitled to the family pension. However, no steps have been taken by the respondents towards release of family pension. That the respondents, in order to redress the grievances of the respondent PTC authorities, in order to redress the grievances of the PTC, required an inquiry to be conducted in respect of the marital status of late Sukumar Kolita. Stop. This inquiry was conducted by the ADC and in charge SDO Civil Salvary. The inquiry report dated 28/12/2023, which was furnished to the District Commissioner, Baksa, and a copy thereof has also been forwarded to the PTC authorities. Huh? No, how have you got a copy?
Forwarded to me.
Forwarded to the BTC authority. Has also received from the state government, Deputy Commissioner's office, has also received from the DC Baksa's office. It's seen that the conclusion in the inquiry conducted by ADC and in charge SDO is that the petitioner had marital relationship with late Sukumar Kolita, and therefore the petitioner is entitled to get the pensionary benefit in respect of late Sukumar Kolita. Stop. Mr. Musahari, learned counsel for the PTC, submits that the PTC does not dispute the findings in the inquiry, PTC authorities, and therefore does not dispute the findings of the inquiry made. Stop. The office of the District Commissioner, Baksa, also has accepted the findings of the inquiry conducted by the ADC, Baksa. Stop. Under such circumstances, where the respondent authorities have accepted the findings, there is no occasion to withhold the pensionary benefits payable to the petitioner. Stop. Accordingly, it is directed that the respondent authorities, more particularly respondent number 236/7 will forthwith put up the necessary pension proposal for issuance of every pension in respect of the petitioner. The proposal be forwarded. It is to be forwarded to whom? Secretary.
No, from DI to director.
From there to director to?
Director to pension.
Director pension. Director pension.
Director to director.
Respondent number 6 to Lordship.
Respondent number 6 to 3?
Yes.
The proposal to be received from the Deputy Inspector of Schools by the Director of Education will be thereafter be forwarded to the Director of Pension, and whereupon the necessary orders for relief grant of family pension will be issued. In the above terms, the writ petition stands closed. The exercise directed as above will be completed within a period of 90 days from the date of receipt of a certified copy of this order.
Lordship, can it be 60 days? It's long pending cases, Lordship.
60 days. All right, 60 days from the date of receipt of a certified copy of this order. Writ petition accordingly stands disposed. Interim orders, if any, stands merged. Mr. Musari for PTC, Mr. Soikia for Director Pension. Your name, please. M. Hussain for Respondent for Accountant General. And S. Kumar for Elementary Education.
Deep level.
My lord, an affidavit has been filed on behalf of the respondent number 2, which is not on record, my lord. Well, Madam will come along with the record.
Have you received any copy?
I have received the copy.
It is not here, perhaps. Affidavit in reply.
Affidavit in opposition by respondent number 2, official.
Respondent number 2.
Lordship.
It is submitted by the Learned Standing Council, NMA. What is that? NHM. That an affidavit filed by the respondent number 2. Affidavit has been filed by the respondent number 2, but the same is not available on record. Accordingly, registry to verify, trace out the affidavit stated to be filed by the respondent number 2 and list the case after 1 week. You want to file a reply?
My lord, no, reply is not necessary. I have gone through the, my lord.
After 2 weeks.
My lord.
Yes.
The date may be fixed. After 2 weeks, my lord.
After 2 weeks. Yes.
Date may be fixed.
You are appearing for?
Respondent number 7.
Respondent 7.
He has been inflated, my lord.
Oh, but nothing has been filed here.
They have filed an IA, my lord. In pursuance of that, IA.
No,
they have
I know, but
inflated and
the
respondent number 7.
post title and everything is not there.
Amended post title.
Amended cost we have already filed.
You have filed.
Yes, sir. Long back we have filed.
Amended post title. Mr. Sarkar, AD Sarkar, the council appearing for the respondent number 7 submits that matter be listed after 2 weeks. You have filed your affidavit. Registry to verify and indicate as to whether amended post title as required to be filed under the rules have been filed pursuant to implement of respondent number 7. Matter be listed
Interim
after
order is operating.
2 weeks. Interim order passed earlier will continue.
Obliged.
Yeah, please, Your Lordship. I have already communicated the Lordship last order to the department, my lord. Not yet received any updated instruction, my lord. Lordship, kindly take that after a week, my lord, that I'll definitely get some instruction.
Dispose of the matter, directing the authority to release the arrear and current salary. It is admitted case that petitioner is undated. After provincialization, he is not getting the salary.
After a week, my lord, Lordship may pass appropriate order, my lord. 1 week.
They have admitted.
Where is the admission?
The director sought for non-royal certificate from the principal. Principal has submitted a non-royal certificate.
Is it not disputed? Amount is not disputed.
Not disputed, my lord.
Okay, where is the non-royal certificate?
That has been submitted by the principal to the director.
Not here. Not available here.
Not available here. After filing the petition, the director of higher education asked the principal to submit the non-royal certificate.
Yes, I
accordingly,
have,
my
my lord.
Huh?
Non-rem certificate is there, my lord.
Available with you?
Yes. Roshni mechanic, from 1 week, my lord, I'll get,
1 week.
yes, ma'am.
All right. At the request of MSPR Monto Learned Council for the Higher Education,
Hello.
matter stands deferred for 1 week. Mr. Ayat Sokia appears for the writ petition. Placed again on 11th, 13th of March.
Lordship, I was suspended, my lordship, without any citing any reason, and I have
Lordship,
been
I have
kept
a-
at a suspension for 5 years, my lordship.
I have an instruction, Lordship. Earlier, the petitioner was served with a notice, Lordship, for a personal hearing. The petitioner failed to appear before the committee. And again, the matter has been fixed on 2nd of March for personal hearing. And notice has been served to the petitioner for appearing before the.
A personal hearing for what?
For regulation of the suspension period, Lordship, the departmental proceeding has been initiated, Lordship.
No, but he's aggrieved by the non-review of the suspension.
My lord, I have been reinstated.
You have been reinstated.
Yes, my lord.
Okay, and
And the
then
suspension was made without any reason. And my lordship-
Regulation.
now that period has not been regularized.
Yes, my lordship.
So let it be after 2nd of March.
My lordship, if they give, I have not received any notice.
I'll
I'll appear
provide
before
you the
the,
copy,
before.
We'll record and keep it on some
Lord.
other date. Heard Learned Council for the parties, Mr. P. N. Sharma, Standing Council Elementary submits that the petitioner was put to notice
Lordship.
to appear before the competent authority, but he failed to appear. The matter is now fixed on 2nd of March.
2nd of March. Lordship.
On which date, if the petitioner appears before the authority concerned, then the department, after hearing the petitioner, will pass appropriate orders in respect to his prayers for regularization of the period under suspension. Let the matter be listed on on 6th.
Yes, ma'am.
6th?
Lordship.
6th of March.
Highly obliged, my lordship.
May I please, your lordship, this matter relates to dismissal from service. In notice was issued, my lord, the government has not filed any affidavit. We have an urgency in the sense that this man is going to retire in this year, my lord. That is, my lord.
You already dismissed?
Dismissed. That is correct. My lord, they are not filing any affidavit, my lord. And it was.
You have, you believe you have such a strong case that you'll be reinstated.
That is another matter, but they are not filing any response.
Yes.
Lordship, we have received an instruction, Lordship.
Matter deferred at the request of MSA Talukdar, who submits their instructions have been received and necessary affidavit will be filed. She prays for 3 weeks' time. Mr. N. Hawk, Learned Counsel, appears for the petitioner, who submits that the matter person being dismissed from service, he has expressed urgency in view of the fact that the petitioner was dismissed from service.
May I pray for date?
Matter be listed again on 3rd April.
3rd April.
Madam,
Yes.
they have already submitted the affidavit. I received it only today. When it
MSS Goswami, Learned Counsel for the petitioner, submits that she has been served with a copy of the affidavit. She prays for 2 weeks.
Yes, sir.
Time to file a response. Matter accordingly deferred at her request for 2 weeks. Mr. S. Dotto appears for the
Number 2.
respondent number 2.
Habla.
They have filed affidavit, the transfer matter, my lord. She was transferred to a school, my lord, and now they are saying in their affidavit that because of that school doesn't have any Assamese teacher. But they did not take into consideration if he goes, there will be no Assamese teacher in the present school.
But anyway, my lord, your lordship will kindly say, I think this case can be disposed of in the same similar order as at page 22. This committee has not considered the matter, but they may consider it.
Committee.
Yes, the committee under the 2020 Act, my lord, there is a committee which is required to see the transfer of teachers.
Yes.
Here, similar order may be passed, my lord, giving them liberty to place the matter before the committee if they so desire. And if the committee feels, my lord, committee may transfer. Shall not, last order, well, it is however made clear that setting aside of the impugn order dated so and so shall not preclude the respondent authorities to take appropriate steps if deemed necessary in terms with the said Act of 2020.
Okay, we have filed an IA in this matter, which has not been listed today.
You will close it with a limited direction that till it is disposed of by the committee, the interim order will operate. You place it before the committee and dispose it off. You file some IA.
Yes, sir.
Let it be on Wednesday then, along with the IA.
I for vacating, they file a petition.
But then if the writ petition is disposed of, the IA will also have to be closed.
Disposed of.
So let it be on day after.
Yes.
It is submitted by the respondents that an IA has been filed seeking vacation of the interim order passed by the court. The same is not listed accordingly. Matter is directed to be listed on 28th, along with the IA stated to be filed by the respondents. Registry to trace out the IA and connect it to the writ petition and list it on Wednesday, 28th. Mr. B.D. Das, Senior Counsel, assisted by Mr. D. 1000 appears for the petition. List on 28th as directed. Copy of this order be brought to the notice of Registrar Judicial.
That will the lordship. They have supposed to file the affidavit, lordship.
Yes, yes.
Lordship, pray for some time, your lordship. Instructions are
Matter
waited. your
deferred at the request of Standing Council, Secondary Education.
Lordship.
List on list after 3 weeks. List on 3rd April. The interim order passed will continue till 3rd, next date fixed.
Interim is there, lordship. Interim is there, lordship.
Yes, yes, we have
Given.
directed.
In this matter, my lord, I have some instructions, my lord. Let it be after 4 weeks. We'll file affidavit, my lord.
Mr. M.R. Odikari, Learned Counsel for the respondent, submits that instructions have been received. He prays for 4 weeks' time to file the affidavit.
I didn't fix, my lord.
Date. Let him file it first. MS so-and-so appears for the writ petitioner. List after 4 weeks.
All right.
Once they file, you may like to file a reply. So after that, better to fix a date.
May I please, lordship?
Yes.
Lordship, the matter regarding non-payment of arrears salary of a retired person.
Why is it for orders today?
On last 12/6/23, the respondent take time to
Lordship, here, the director has asked the inspector of schools to resubmit the area proposal, your lordship. Because certain discrepancies were found in the proposal that was sent earlier. So now they have asked to send it again. On 9th of January 2024, it was sent. It was communicated to the IS.
Matter be, since notice was issued in this matter as far back as 27/9/2022, let the matter be listed for admission. After 2 weeks.
Lordship.
MS so appears for the respondent. After 2 weeks.
Obliged. Okay. Obliged. 49, your lordship, we have received, we'll be filing it today, your lordship, the affidavit in opposition, your lordship.
Your lordship may kindly see the last order dated 1/2/2024.
You have still not filed it.
Lordship, after some time, can it be taken after some time, no, Lordship?
We'll record your statement that you are filing it today.
Lordship, we are filing it today. In fact, it must have been filed, Your Lordship. We have
Heard Learned Counsel for Parties, MS, the Mushahari Learned Standing Council, Secondary Education submits that the affidavit on behalf of the respondents have been filed today.
Lordship.
The Learned Counsel for the petitioner, however, submit that no copy has been served. Be that as it may, the matter be listed after 2 weeks.
Okay.
Any affidavit that is filed by the respondents be tagged to the connected to the case records by the registry.
The date may be fixed, right?
Date. List on 20 March 20.
I will be out of state.
Give us
Before.
your dates.
And then, madam, 15, 16.
15, all right.
All right.
15 March.
Lordship, in 50, Lordship, we have received the instructions, Lordship. Would like to file our affidavit.
They have received the instructions.
Hello.
They would like to file their affidavit. But service on respondent 427,
Which service, madam?
await service. Office record, office note dated 16/2 reflects service on notices on respondent 427 have been undertaken by registered post. However, service report is not received back as on date. Await service report list after 4 weeks. Meanwhile, the respondents are at liberty to complete their instructions and file necessary affidavit if so advised.
Right.
List after 4 weeks.
Obligation. Obligation, Lord.
Eight, Mr. Lordship. Lordship, in office notice dated 1st of February, notice issued upon respondent number 225 by registered post.
Lordship, I am appearing on behalf of 2 to 5.
You are
I
appearing.
filed the wakalatama today only. 4 weeks time will be given for
Mr. Gupta
Gupta, K.
appears for respondent number 225,
2 to 5.
who submits that he has submitted his power, he has filed his power today. He prays for
4 weeks time.
4 weeks time to file his reply. MS
J.S. Das.
J.S. Das, Learned Counsel appears for the writ petitioner, and Mr. Kolita for
Respondent number 1.
respondent number 1. Matter accordingly be listed after 4 weeks.
Obligation.
Yes.
Lived.
In this matter, Mr. P.J. Shukia is lax on court number 2, my lord. So if possible, then for the timing, and if not possible, my lord, then taken up any other case.
Matter be listed again after 1 week,
Much of it.
as the Learned Counsel is not available for the petitioner. Yes, we will.